Finally.
When did we start formally the project? It was in 2000 and
Last year only.
it was only last
Yeah,
year
yeah,
formally.
yeah.
Yeah.
Yeah,
Okay.
in May. In May.
Yes, in May.
And
Okay.
we immediately had the conference in August, so we were
Yeah.
early.
Okay.
Are we all?
Okay. And and CAPES is to explore the potentials of AI certification, so certification frameworks and schemes for as a tool for AI regulation. And we have, let me just quickly present the teams so that we get a more personal touch. And so the German team is then composed by researchers both in the field of computer science and law. Professor Georg Borges leads the legal side of the research in Germany, and Holger Hermans on the computer science side. We have then Afolabi, Julian, Lino, Jonas, and Howie. Uh, and from the Brazilian team is a little bit larger. So myself, Juliano Maranhão, Renata Wasserman, João Pereira, Eduarda, Stephanie, Gabriela, Marina, Anderson, Tyrone, André, and Rafaela. Not all of the team of the Brazilian team is here. The German team is fully present. This is not forgivable because, of course, the German team would have more difficulties to come to cross the ocean. But anyway, the rest of our Brazilian team is following it online. So this first meeting, we have already had a meeting in the University of Saarlandes where we made initial discussions for this project. And then this week, 1 year after our joint project, we chose as a subject matter the challenges for AI certification. What it did until now was to map the main challenges and difficulties. Both the German team has focused on the EU AI Act regulation and specification of the standards, efforts of specification of the standards in the European Union, while the Brazilian team has worked on international standards of private entities of certification and standards, trying to systematize the several documents that we find and are important in the context of certification and also standardization in industry. So yesterday we had a meeting, closed meeting, just with the researchers where we have exchanged some initial findings and discussed how to integrate these two perspectives, the official European efforts on standardization and the private efforts of standard entities, standardization entities for the certification of AI. So today we are now beginning a seminar with also invited professors to discuss the challenges not only for compliance with AI standards in Europe and Brazil, and also we are going also to focus and present some of the aspects that are relevant in our ongoing research. So thank you very much for coming. I already spoke too much, and I'll give the word for Georg, and then let me first to Renata, a lawyer, then a computer science, then a lawyer, then a computer scientist.
Well, good morning, everybody. Computer science typically speak less than lawyers, so I'll keep it short. I just wanted to welcome everybody. And from the computer scientist point of view, this is a very important topic. We see people struggling with what they're doing and with the effects of what they're doing, but in computer science courses in the curriculum, we don't learn how to deal with the human part of our work. So we are trying to improve that. So welcome, and have a nice day here.
So, yeah, good morning, everybody. On behalf of the German team, well, it's all said now, so I can just add a few silly remarks, and I will not hesitate to do so. Why is it important to come to Brazil from a European perspective? Why did we have to travel in a long distance flight and so with the whole team? Well, just because if you come to Brazil, you will discover something very new and unexpected. Yesterday we learned that almost all of the judges in Brazil are already working fully equipped with AI systems, doing the work for them, boosting their productivity by factor 10, which means that we need 10 times less judges in Brazil compared to Europe. And it seems to be worked well. No one's complained so far. What does this mean? We are way behind Brazil in Europe, and we will have to work hard. It's not only China, obviously, that is developing and using very sophisticated AI systems that are changing our societies. It's also worth looking at Brazil. That was a big finding and somewhat unexpected. Just because against the background that I'm a member of the board of the biggest association on e-justice in Europe, the German EDV-Gerichtstag, and we are struggling for decades to digitize our courts. I think just the German ministers should come to Brazil to see what happens here. But maybe next year, when the Brazilians will visit us, they might also be amazed of seeing the discussion of all the problems coming associated with the AI system and the challenges that are really there, and that will not leave us. They will give us work for the next decades to come. I'm very optimistic. So we will not need less lawyers in the end. That's my promise to my students, to everyone in here. The AI systems are kind enough to produce as many new challenges as they solve in the end. So there's plenty of interesting work to do, and we are looking very much forward to tackling the challenge together with the Brazilian partners, and of course in an interdisciplinary perspective, since that is what counts.
All right. Yeah, my name is Holger Hammers. I'm a professor of computer science at Saarland University. I mostly work on verification, which means I try to make sure that systems do what they're supposed to do. Now, what we are seeing with this wave of AI is we are seeing that it gets very, let's say, cheap, very effortless to get things done, including things that happen in court. At the same time, we are living with a situation that the quality can be extremely off what humans would obtain if they would look at that precisely, right? But on average, it works quite well. And so the question is, why would we actually certify these kind of things? I mean, if it's just getting cheaper to get something done roughly, then I think there is not really a need for certifying this. But of course, if these are high-stake tasks, then the situation changes. Then, right, we need some sort of baseline which helps us to say, okay, at least the system was well designed, and so forth and so forth. Whether that is attainable, I would say the computer science community is not so sure whether let's say hard guarantees about these systems can actually be made. Likely they will be soft. And this is a bit inconvenient for people like me who do verification, I guess for you, Renata, as well, right? And this is what we are living with. At the same time, we are happy to talk to the legal teams that are present here. Of course, this is mostly a legally dominated consortium that is doing the work, but we are happy to consult with them and give our opinion. Yeah, thank you.
So let us then begin just to explain something about the program. We are going to start discussing certification and regulation of AI in Europe. Then Georg Borg will present the initial remarks. Then we move to an experience in Brazil for a sandbox that's going on in the Data Protection Authority about AI, and is a project that is being developed by the University of São Paulo. I brought Cristina Godoy here. Then we moved in the second panel to some technical issues, and later, just for you to understand, we brought some specialists about certification in the environmental field. And why that? First, because there is a discussion of certification of AI systems in terms of sustainability, energetic, and resources consumption. But also because certification, the AI certification framework may learn a lot from the certification frameworks in the environmental field. And then we are going to have a roundtable in the end to discuss some of the findings that we have developed today, and particularly we brought some representatives of the industry to share some of their difficulties in implementing AI, and also to bring some of their reflections and ideas about certification. So thank you very much. I will leave the room now and give the floor for... No, I'm not going to leave the room. I'm going to give the floor to Georg.
I need the HDMI.
Okay. Or maybe because can you do it, because I sent it to the yesterday it worked. Yeah, but let me see if you can connect.
But where's the HDMI?
Yeah, the cable is not here. Yeah, or you could also send the presentation to the email, but let us see. I think Georg would rather present it with his machine.
Maybe that hurts.
So the question is, but I cannot enter the... So, what about online? Is it possible to see the slides online at all? First of all, the mic. So the question is, can online participants see the slides at all? Okay, as a part of the screen. Okay, then let me start. Okay, for the next 30 minutes, I will talk. Let me briefly introduce myself. As you know, and as you see, I'm wearing ties, so I must be a lawyer. And actually, I'm the director of the Institute of Law and Informatics at Saarland University. And the said institute is working with an interdisciplinary perspective in many fields of technology and law, with a focus on AI recently. We are also involved heavily in education with different programs. Our flagship here is our master's degree program IT and law, which is offered in German language only at the moment. It's a one-year program that is very popular among professionals, actually, who want to enlarge their knowledge in this field. Last thing about the introduction introduction of my institute. I hope to see some of you, at least, again in August, when we organize our annual summer school on IT law and legal informatics. It is interesting as it is a graduate law school, so quite different from what you understand normally by a summer school. It invites current topics related to AI and law. Professor Maranhão has repeatedly served as a part of our team as a lecturer here, and last year we had our first conference as a part of the summer school. This year I hope it will be interesting again, so please just look at the website and tell the news to everybody. Now there's a lot of work to do, so I will rush through the agenda and start with the introduction. When we talk about certification, we talk of very different aspects. Certification can be an instrument of legal regulation, and we use it widely in law already. You all know product safety law if you're European. Outside Europe is less known, actually. It's a body of law that is unknown even to most German lawyers, but very important in practice. There is no product on the market without the CE seal, and that is product safety law, and it's well known in IT security law and other areas such as banking law. So this is one established part of certification. And another one is also reputation. Professor Maranhão yesterday told about the value of certification as a basis of reputation, or as we call it, a basis of trust. And that is also regulated by law. Some of the European acts, such as the Data Governance Act, rely on the legal framework for voluntary certification that is aimed to establish trust in new technologies. And obviously there are a lot of legal questions around certification and technology. And I just have a list of the 5 main questions here that are the core of our project. We have to ask what the subject matter and significance of certification is. What is really a conformity assessment, and what makes it different from a certification? What is the legal framework of such conformity assessment and certification, and what is the scope of it? And last not least, what is the procedure of the certification? As we know as lawyers, if it doesn't come in a well-regulated and well-established procedure, the value is doubtful. And last but not least, the legal consequences. What does it mean to be certified or not certified? What does come with it? And that for each of these 5 aspects, there are very different solutions around, and it's very important to understand the different options that we have here in order to create an AI-related certification. That's what we're talking about. There are also different concepts around. We know quality seals of any kind. I think we are surrounded in our daily life by quality seals of whatsoever nature and whatsoever kind. They're very different. And we know the notion of, even if you're not familiar with the notion of conformity assessment, it just means a checking of compliance of something with somewhat. So that is conformity assessment and certification to be distinguished from conformity assessment, at the same time also from quality seals. What makes it confusing is that the words and notions are used synonyms in partly, so we never quite know what people are talking about when using a term. That's why we have to classify the concepts and better understand what the characteristics of each of the concepts really are. When we scrutinize and try to understand a specific certificate or quality seal, we have to look at different aspects, characteristics of them, such as the statement. What is the statement that the quality seal means? Can mean I like it. You know the like it button. You like it. Doesn't care why you like it. You can say how much you like it by giving 1 to 5 stars, but your criteria is your secret. You're just I rely on you because you like it, I must like it too. Nice. But you can go into more detail, asking, is it good, very good? Is it better than something else? Does it meet any requirements? And so I think you understand what I mean. And the question is, who is making the statement? Does it have to be a qualified auditor? Is it just my best friends? And so on and so on. Where has the statement been made? Why? What is the basis of the statement? Just personal preference or a assessment or whatsoever? Do we have a period of validity? The hotel that we visited 10 years ago doesn't have to be the same standard anymore. So obviously there's a lot of limitations and aspects that have to be observed here. And then it comes to testing. Since testing doesn't have to be, but can be a part of conformity assessments. Surprisingly enough, most of the conformity assessments that we talk about in the context of the AI Act do not include testing. This is the biggest surprise when I talk to technicians. We have a big bunch of conformity assessment without any testing. So, but when we do testing, then the question is, who does the test? Who is the examiner? What is exactly the object of testing? And what is the standard against which we test? And what is the procedure? Now let's see what the law can do for certification. And of course we can address each of the elements of the certification procedure. Very important is to regulate the content of the statement. When we have financial statement that is the subject, it's very important to see what it really says. And the question, what is last but not least the legal significance? It can be used as a means to avoid liability, for instance. It can be used as a precondition to enter the market, as we do in banking. There is no banking outside of a conformity assessment and so on. And the same goes for some part with AI certification or AI conformity assessment. And again, there are more parts that we can look at from a legal perspective. I skipped it for the sake of time. Now let's go a bit more specific in product safety law, since since the AI Act and many others is part of product safety law. Product safety law is a European property. It's not available in most other countries. That's why a good question is, do we really need an AI Act drafted after the European one if we don't have product safety law? You will see in a minute what I'm talking about. Product safety law is a well-established field of law regulating product safety requirements. The objective obviously is that we have safe products on the market in the EU, and we define the safety requirements by legal acts, so by law. And the regulation of safety requirements is usually specific to products. They are there are different safety regulations and different legal bases for cars, airplanes, medical devices, and some others. It's not only about certification. There's also usually monitoring by authorities having strong investigative powers and even the power to to order recall of products, which happens quite often actually, and also to impose fines in case of violation and non-compliance of the rules. So it's a very massive legal body which comprises about 20 European regulations and directives. So it's a quite part of law. And for us, for instance, our medical devices regulation is important as it's related to AI quite a bit. And of course, any of these machinery regulations, as you nowadays many products contain AI as well. All of the different acts that are part of the product safety law regulate for conformity assessment. This is the central element of all of it, and they make use to the so-called CE marking. You will see the seal on the slide that you find on almost any product that is sold inside Europe. And this seal is just a declaration of the producer that saying exactly that the product is complying with the respective legal requirements. So it's a self-declaration actually in most cases, but it shouldn't be missing. Otherwise, not placing the CE seal on a product that is marketed in Europe, it's itself a violation of product safety law and can be subject to a fine. One interesting aspect is that other to my naive first approach, the basic rule of a conformity assessment is a self-conformity assessment. It's just a self-organized procedure by the manufacturer, and the manufacturer is himself placing the CEs. Also, there's no authority, no third party usually involved. Only in the case of some particularly risky products such as cars, medical devices, third-party testing is required. If you look through a very different field where certification has a different function and role, data protection is a good example. As the GDPR has some rules on certification as a voluntary certification, offering legal benefits for certified applications. Interesting enough, that is not widely used yet in the EU for reasons I don't fully understand. It is also interesting to note that we don't have data protection certification standards that are available. So maybe this is one of the reasons. If there's no standard, you cannot obtain a certificate, which makes it difficult to use it, obviously. It is interesting. I developed a certification scheme based for the prior German law, the so-called Trusted Cloud Certificate for Cloud Computing Services, and there is a follow-up project, but it took 7 years to develop the certification scheme and get it accepted. So you see, there are some challenges in establishing certification schemes, and AI might pose similar ones. Now, let me talk a few minutes on the AI Act and certification. I don't have the intention to introduce the AI Act to you. As you know, it's a massive piece of law comprising 113 articles in 13 chapters. It's a lot, actually. When it consists of 4 different concepts, and I cannot highlight enough that although there are prohibition of certain practices, although we do have this chapter on high-risk AI systems and even one article on transparency, the biggest chapter is no regulation. between 90 and 99% of all AI systems are not subject of any duty under the AI Act. Just keep in mind, 99 to 90% is not regulated in the end. The addressees of duties under the AI Act are mainly the provider, being the manufacturer of a product or an AI system, and the deployer, this is the operator of the system who runs an AI system. Not, however, the user of an AI system. So when I use ChatGPT, I'm not addressed by the AI Act at all. Now, let's turn to the high-risk AI system regulation, since there we find certification. The chapter on high-risk AI system consists of 5 sections, each of them addressing particular aspects of it. The first one being the classification of AI systems as high-risk AI systems. And here we have 2 very different groups and concepts. The first being defining AI systems as a safety component of a regulated product. Regulated products are those which are regulated by product safety law, such as car, medical devices. And here, the AI system is high risk if it is such product or a component, a safety component of such product, and second condition, if that product is subject to third-party assessment under the respective regulation, which is the case for some, but not the majority of regulated products. Medical devices and cars are, most other products are not. The second group of high-risk AI systems are AI systems for use in so-called high-risk areas. And here we have a catalog of 8 high-risk areas, including judiciary. So AI systems to be used by judges are high risk in general, and also some used in the HR for decision making. In general, AI systems that make assessments on persons are considered high risk under that concept. However, only if they are really posing important risks to personality rights. So even an AI system is used in courts by judges, it doesn't have to be a high-risk AI system. It's only considered high risk if by an analysis and assessment of the risk associated with the said system, it is found that they indeed pose significant risk, whatever significant means in this context. And that is part of our research. What means significant in that field? If we classify an AI system as a high-risk one, then the duties and elements of the so-called risk management set forth in the AI apply, and it's mainly risk management in the meaning of what we understand by risk management. It's nothing else, together with some very obvious duties such as record keeping, technical communication, human oversight, cybersecurity, and last but not least, as it is the most tricky one, data governance. The Article 10 on data governance is hard piece, since it talks about fairness and bias, whatever that is in a technical perspective. The provider of such system does have to establish risk management. He does have to organize conformity assessment for the product and register it in the European high-risk AI database. So, if you take it all together, it is obvious that the EU AI Act is a specific product safety law. It's not a general framework for AI at all. It's a very specific piece of law, nothing more and nothing less. Now, I have 5 more minutes, Giuliano. If you can give me this, then let's go to the conformity assessment under the AI Act. It is regulated in Article 43 together with 2 annexes, Annex 6 And 7.6 is self-assessment, 7 is assessment by third parties. And the standards against which the conformity assessment has to take place are the so-called common specifications or harmonized standards that are to be developed by SAN and CELELEC but do not exist yet. We are waiting for them like for Christmas. And maybe they will be finished by end of 27, which is good for us since it's perfect for timeline for our project. When we look at the conformity assessments according to the AI Act, then it is interesting to see that here the principle is self-assessment by the provider. And you do it as you do it. There are rules on it, but if you look at Annex 6, and we do not have the time to go into it today, it's rather short. It's 3 sentences, not more. Just 3 very general sentences of how doing the internal assessment. Good luck, I can say. Good luck. Because if you are a small or medium enterprise, you wouldn't have a clue how to do the conformity assessment. So you need special agencies, and they are preparing for the demand at this moment, obviously. If only 1% of all the AI system is high risk, so what is certification all about? We have to think about voluntary certification, since this is for the big bulk of the AI system that also pose risks, and we also want to rely on all the other systems that we are depending on in our daily life, isn't it? So that's why our project has a second goal, that is to explore the potential of voluntary assessment of AI certifications. And luckily enough, the AI Act is very friendly against voluntary certification. It strongly encourages the establishment of voluntary and self-regulation in broad sense. For instance, Article 95, the Codes of Conduct, would allow for a voluntary certification scheme. So, I really cut it short here. The AI Act does not exclude at all voluntary certification, rather it's encouraging the development of such certification schemes, and that's why it's worth thinking about what a reliable certification scheme would look like. And then we are facing some challenges, and I'm just highlighting the obvious ones here. It is very difficult to understand what technical requirements have to be in place to protect personality rights. That is not well understood yet, and that's obviously very difficult. And as I told you, the standards, the harmonized standards, are not in place yet. So let's put ourselves in the position of the European legislator. What should we do? The one option is the postponement of the obligation to conformity assessment, and that is the solution that the Commission was choosing. As you know, there is this digital omnibus on AI regulation that has been proposed by the Commission in November last year, and that will probably be finalized in May, so in a couple of days, and will enter into force probably in July, early enough to for the postponement, since according to existing legislation, all the rules regarding high-risk AI systems in the second field, which is the catalog ones, so judiciary ones, will be applicable from 2nd of August already, but they will be postponed to December 27, so 1 more year time. And Professor Hermans already asked, kind as he is, yesterday in our workshop, what is then? Will we have the next postponement? Because he thinks it's not possible to come up with the satisfying standards in only 12 months. And my advice would be, yes, please postpone again if necessary. It's better to have a good standards 1 year later than to have a standard very early, but who doesn't help us. The second option would be simplify it. Why do we have to have a standard that cannot satisfy in a mission impossible, so to speak? Why does it have to cover things that we cannot cover by technical standards such as fairness? Why do we have to have fairness standards in a technical standards that has to be brought down to tick boxes? I don't see this really. There was demand for simplification on part of the industry. However, according to the digital omnibus on AI, there is no material simplification in place yet. So we will have the full task to comply with. And of course, we could abandon from it. We could make it the field of application even smaller. That's exactly what the omnibus did. I think my personal guess is that the number of high-risk AI systems is decreased by 10 by the digital omnibus because it eases quite a bit. And of course, we can develop AI systems in Brazil rather than in Europe, would make it easier to escape AI Act. Or we cannot, lastly, not use AI in Europe, but that is obviously not an option. So I think it's not so easy to solve this challenge. Another question would be, is it possible to not have conformity assessments like the US does? US relies on liability very strongly. So it's two completely different concepts. Don't regulate it, just make them liable if anything happens. What do you think of this? This is the biggest debate that we have in the global discussion. Should we incentivize by regulation or by liability, as the US does? Of course, being a European, I strongly vote for regulation, for legal certainty, and also I think for efficiency. But this is something we have to establish throughout the project. It needs a very good foundation, since the rest of the world is waiting for an answer to this question. As you know, in many parts of the world, the legislator follows a wait-and-see approach. They want to see if the European can manage their approach, and they want to see if it's convincing or not. So our project is part of a very global and intensive discussion on how the future of new technology regulation will look like. So to conclude, we need conformity assessments based on existing European framework. We just need it in our system. Doesn't mean that Africa needs it to the same extent, since they don't have the same approach to product safety, and US doesn't need it at this moment since they have a different approach. However, there might be some advantages when using this approach, such as legal certainty and efficiency, if and only if we will be able to develop convincing certification schemes. Thank you very much for your attention. So this.
Any questions from the audience?
I think I also used my time for the
Okay, we have time for questions, for some debate. Anyone in the audience would like to bring some questions?
No objection.
Do you think that it's possible to have certification that, for example, it's developed in European Union, but all countries could, in international level, we could use this certification, or the certification is something that it's connected locally, and you need to
Okay.
verify all the regulations
So the question is a very good question. Thank you very much. So the question is, if the European Senate would manage to come up with the standard, would that standard be to be used in a global way? Can it be used by other jurisdictions? That is the question. And of course, yes, it will be technical standard like the other technical standards. Senselect is just a certification body as others are, or standardization body, not certification actually. And of course that standard can be used and will be competing with the NIST standards and other standards that are around. Just, there's no recording here. I have a bet with my friends. What we all were interested, what will the certification look like? And the biggest divide in certification is management certification, which is entity certification, so you or product certification. And the certification requested by the AI Act is product certification, which is totally different from entity certification, where you certify a management system, such as ISO 9000, which is popular because it just certifies the management in general, not a single product. And my bet is that the Commission, in order to make it possible at all, will try to turn the product certification into a management certification by saying the product is safe if there's a good safety management. This is the only way to come along with it. That's my guess. Let's see, in 60 months we should know more. And that would be, of course, to come back to your question, that would be free to be used elsewhere as well.
Yes, I think with the agentic AI, this makes more sense because you need to check out the management perspective, not only, for example, AI as a system, only checking out the model. Agentic AI, you will need to check out all AI agents, orchestrate, and
Yeah, so
so this is a matter of management. So I think that you will make the
yeah, but thank you for this, because I can object now. When I developed the data protection certification scheme, I developed a product certification. So the subject to certification was the cloud service, not the management of the cloud service provider. And that was a challenge. That was a specific challenge, in particular if you have services that rapidly change as cloud services do, or if you have a technology that is rapidly developing such as AI does. However, even with a good management, you can end up with a very bad and unsafe product. That's why I like product certification. I want the product to be tested. I want a safe car, not a good car manufacturer management. I want to rely on the safety of a car. And I don't care if the management is really good as long as the car is safe. But if I have a prestigious management and that is really have all these quality seals, but the car isn't safe, what is my benefit? But it seems that the only way that is really doable is procedural rather than material certification. Maybe a kind of compromise between the two systems is what we will reach in finally. But this is the tricky part, definitely the tricky part. So thank you very much for your remark.
Thank you. So thank you very much. Let us close this this initial presentation, and then call here Cristina Godoy to talk about the NPD Data Protection Authority sandbox on AI and this experience that we are working on together in this project.
Let's hear my presentation.
Acho que
Yes.
sim.
Será que fica no final da apresentação? Não. O que eu faço aqui? Eu leio diretamente. Hello, everyone. I'm glad to be here and share some insights about our pilot project of regulatory sandbox on AI and data protection. That it was launched by our data protection authority here in Brazil. So, first of all, I would like to make a short introduction and a background about this project. The pilot project was launched last year, but this started much earlier. So the regulatory sandbox on AI and the data protection here began in October 2023 with a public consultation. I think that this is the start point because our data protection authority started to think about sandbox on AI and also to collect the insights from academia, from civil society, and also public sector. All this material was published, and we have the English version also. So we have in Portuguese course and in English. And it was very good to have an overview of what people think about regulatory sandbox, and it's a great material. Also, we have a call for contributions designed to collect insights from experts, companies, and civil society. We have another report about this. Juliano and I, we also share some insights in this public consultation in that moment. And we also published the material. And the third point here, it's that it represents the first AI-focused regulatory sandbox on AI in Latin America. So this was also very important here. I also would like to present our team here. First, I need to explain a little bit about this. Before we have the public call related to the selection of companies to participate in the regulatory sandbox, we have a public call to select public educational institutions that will give all the support for our data protection authority. So we participated in this public call as CIAN. CIAN is the Center of Artificial Intelligence and Machine Learning at the University of São Paulo. I'm an executive member there, and we submitted our project to the Data Protection Authority with other universities that participated in this public call. We were selected. So we have a team that developed this project, and the team is myself as a coordinator, general coordinator. We have also the technical team that is leading some areas that we are developing our test. And we have João Paulo Candiaveiga, Carlos Portugal, Juliano Maranhão, Ana Rosa Brandão, that you will listen here today after my presentation. We have also our post-graduation researchers, that it's composed by Rafael Meira Silva, Thiago Gomes Marcílio, Antony Novaes, and Fernanda Versiani. And we have also Luciano Galegos and Giovanna Carneiro. And we have two international consultants. Vasilka Sansin at the University of Ljubljana. Vasilka Sansin was leading the regulatory sandbox on AI in Slovenia. And it's why she is part of this project as an international consultant, because we wanted to share some experiences between European Union experience on regulatory sandbox and Brazil. And we have also João Pita Costa, that is a researcher at IRCAI. It's a center of artificial intelligence, a UNESCO Center of Artificial Intelligence that is based also on Slovenia. And João Pita Costa, it's an important key here because we are using the UNESCO framework related to ethics and AI in this project, and his experience is very important in order to have some tests connected with ethical issues here. So, talking a little bit about the background, why a sandbox now? Why Brazil started to thinking about this? Because we do not have a bill, AI Act as European Union. We have a bill. We have a bill 2338 that it's under discussion even yet. But we have also the European Union Act that was shaping the discussion with the risk-based approach to AI regulation. And we see this in our bill also that it's under discussion here in Brazil. We have the Brazilian National Strategy, and we have both EBIA and PEBIA. PEBIA is the last one that was published in 2024. That was aligned with the OECD AI principles. And then we check out the Data Protection Authority that saw as an important opportunity here, because to use the regulatory experimentation as a bridge between innovation and compliance was an important point in order to establish the importance of the Data Protection Authority here. Because in the bill 2338, the Data Protection Authority is leading our AI system, our system of governance. And so with this pilot project, it was an important moment for our Data Protection Authority. And finally, the sandbox would allow Brazil to test AI systems in practice, gather empirical evidence, and co-designing regulatory solutions before formalizing new rules. So it's why it's a pilot project. It's not a project of regulatory sandbox. The idea here is to collect insights, protocols, and some ideas in order to inspire other regulatory sandbox that will be launched with other authorities here in Brazil, sectoral authorities as the health minister. We have now the educational ministry. Here is Ana Rosa that also participates in our team. So the educational ministry here in Brazil also is conducting a regulatory sandbox. And the second question here is, what's a regulatory sandbox? So for people that have some doubts, it's why I have this slide here, because a regulatory sandbox is a controlled environment that we will conduct the tests under realistic conditions, but without exposing people to harm here and the violation of human rights. It's not a deregulation, it's a evidence-based regulation. This is a good approach because you have this discussion and the interaction between regulators and the innovators. We have a temporary flexibility and the continuous supervision here, and the idea is to continue this idea of a regulatory sandbox, and we have this in a database. We cannot only have this pilot project and with this, we need to continue everything that we started now and also improve what we are doing now. Also, the regulatory sandbox help us to identify risks early and design proportional safeguards. And also Brazil's models draws from its startup legal framework. And this is why in our public call for companies, we also have an article that in the classification phase, we give additional 3 points in addition to startups, because we wanted to foster the participation of startups in the regulatory sandbox. It was hard also because all the costs of the regulatory sandbox will be in the back of the companies. It's not the data protection authority that will pay all the costs. It's not like Spain and some countries in Europe that you have a budget, a public budget to conduct it. And also, our data protection authority, before launching this public call, have some benchmarks like UK, Norway, and the ICO in UK sandbox was a major source of inspiration. So one aspect of the ICO sandbox was connected with innovation. It was very important to demonstrate innovation. And when we started the selection of companies, we have two criteria. Criteria connected with the elimination criteria, and also the classification criteria. And the innovation was in both of these criteria, in elimination and also in classification. Participants receive direct regulatory advice throughout development, and it's what it's happening now. And also findings are anonymized and published as best practices models. And we are now finishing the first cycle of tests, and we will start to publish our reports, and we will do as we will first submit a report to the Data Protection Authority. This will be a big report, and then we will have a short version that will be published in the Data Protection Authority website in order to share all the insights. And we will do the same that we check out in UK. So responsibility and innovation, these are two important points to our regulatory sandbox. So participants remain reliable for damages, and we also want to prevent misuse to mature our routine process. It's why it was so important, the innovation criteria. The idea is also to analyze the proportional risk mitigation, and we want to avoid excluding startups here. And it's why in the selection part we didn't ask so much documents and the risk assessment from companies, because the startups are not able to develop in the necessary ways. So this is an important point. And finally, sandbox only for truly innovation solutions. Innovation was very important to the selection of companies. So when we talk about our national framework, first we can check out that we have a fragmented initiatives. As you know, we have the central bank initiative, but it's not connected with AI. It's a regulatory sandbox. We have also our stock market commission also that issued this. The security commission, SUSEP, also launched a regulatory sandbox, but a regulatory sandbox on AI and the data protection. This is the first one. The idea here in Brazil, with our Bill 2338, it should have a unified framework under the AI system, the CIA, that it's led by the Data Protection Authority, if this bill pass. I saw in the newspaper yesterday that a deputy stated that they will pass this bill on May. I'm skeptical also, but maybe we will have this AI Act. And also, it's important here in our bill because we are discussing in a chapter connected with innovation the sandbox, so it's important to also sandbox on AI in our bill. And the idea is to unify to have a unified and harmonize the rules connected with a regulatory sandbox, because we have also, for example, sandbox in Rio de Janeiro, in other states here in São Paulo, and so on. So we have also, we are a federation, so we have also other levels that are launching regulatory sandbox, and there is no problem, but we need to unify this in order also to have unified results, and we could learn from all these experiences. So the standard phase in our bill is design, implementation, monitoring, and the closure. And finally, it's very important to guarantee the transparency, the public reports. So we need to publish the reports with all the lessons learned and the regulatory improvements. Because if we want to have a successful regulatory sandbox, we need to have also regulatory improvements. We have doubts about that innovative solutions, and we need to check out which kind of solution suits best in that situation. It's not to stop innovation, it's to understand what's the problem and have regulatory solutions that it will be issued by the authority. So for our perspective also, it's important international cooperation, because AI has no AI doesn't respect borders. And if we thinking about escalation of solutions, it's important to have a standard. I know that the regulatory sandbox also it's connected with the legislation, all the regulations in a country, but we need to have a harmonized also standard when we think about international cooperation in order to have this kind of escalation solutions. So European Union, it's an important moment for us now, because European Union recognizes Brazil as adequate for international data transfers. So this is important for us now. It's an opportunity for cross-border AI sandbox. And the priority here is harmonization of rules, reciprocity in markets, protection of rights, and innovation with social environment impact. UNESCO is also thinking about a regulatory sandbox, for example, here in Latin American region, Caribbean also will participate. So we need to think about regulatory sandbox in the international perspectives, and we have some experiences like in Singapore, in US and the other countries that they have a pool of countries that are issuing regulatory sandboxes. So the closing remarks connected with this project is sandbox. We need to think about a mutual learning lab here, because we need to have experiences that will be exchanged between regulator and innovator. We need to protect rights while enabling innovation. This is very important, because as I told you, we do not need to think about stop the solution. Oh, it's a danger and we will stop. No, we need to check out which kind of solution we could build here in order to have an innovative solution, but that respect the fundamental rights here. And this is important here in the Global South, because, for example, I participated in a conference in Paraguay, and they wanted to understand a little bit more about regulatory sandbox and how Brazil is conducting, and all the region also. It's interesting about our experiences. So for us in the Global South, it's very important if we think about also AI governance. Only to highlight here, we finished on February our training phase. Participants went through a training cycle composed of 14 sessions, included 2 simulation exercises and the submission of 2 complementary assignments. And in the end, they needed to submit a sandbox plan and a discontinuity plan. So this training, it was very important here because the participants do not have the same knowledge level. So it was important here. And also one thing that I would like to share with you, companies think that when they submitted their project, they think that a regulatory sandbox is like a compliance or a consultation, and it's not. As we saw, it's a controlled environment of tests that we will conduct in under realistic conditions in order to check out all the doubts connected with that solution without exposing people and the fundamental rights. So this is very important. We are not doing a compliance service here or a consultation. And the training was very important here to explain this. This is a lesson here. I think that we need to share more results about the regulatory sandbox, and we need to explain to companies what's a regulatory sandbox, the idea, and how it works, what's a plan of sandbox, and so on. Because with this kind of knowledge, the experience will improve in each new regulatory sandbox. So the objectives here in the training phase were organizing human resources and the infrastructure for testing. It was very important to have everything in place in order to avoid the delays, because we will need to finish everything in the end of this year. And Ana Rosa is now laughing about this because we have a very short now period to finish everything. Also, we need to have a clearly understanding the sandbox objectives, and it was important for companies, and they also provided the necessary content for structuring the plan of sandbox. Companies will need to identify all the objects that will be tested, and in which moment, and what they have as a regulatory doubt about that solution, that we need also to have a regulatory test. So how it's structured, our testing phase? We will have 6 testing cycles. We are finishing now the first one. Each one will have 3 phases. The phase A, that it's a pre-testing, and we have some forms that the companies and also our team at CIAM, the Center of Artificial Intelligence and Machine Learning, will need to fill these forms about the companies, and everything will be organized to the next phase, that it's the B phase. And then we will conduct the experimentation. So we split our team. They are working together, but we have the technical team that it's led by Ana Rosa now, and they will have this technical test, and also we have the regulatory team that, of course, will conduct the regulatory test. So it's important also to highlight here that we will use a Brazilian tool to make the assessment with companies that will use LLMs. The name of this tool is ARPIA, that it was developed in the C4AI, the Center for Artificial Intelligence. Also, we have the participation of Ana Rosa, Sara Jane, and Fabio Cosman. This ARPIA, it's an important tool to assessment of LLMs. We have 2 kind of tools. We have the ARPIA survey, that we will have people that will check out with questions if the LLM we identify bias or unfair answers. but we have also the automated RPA, that we will have also the automated assessment of these LLM tools. So we have three components that were selected in the regulatory sandbox, and we have two that will use LLMs, one in the health sector and the other one in the cybersecurity for financial institutions. So it's why it is very important to use the RPA, and it's good because it's a solution here at the University of São Paulo. And finally, we have the phase C, that is a post-testing. The idea is to review everything that we have done and what we collected in this phase of testing, identifying what the company will need to do in terms of adjustments, and also the plan of discontinuity review, because it's dynamic, and so they presented the plan of discontinuity in the beginning, but now we will update it because in the final cycle they needed to stop everything after we conducted the last test. So here are some partnerships. This was an international seminar that we shared some experiences on August 2025 in SEBRE, here in São Paulo. Also, we have some publications connected with this, and Juliano is also here in this picture, and our international consultants in the project. And it was very important because we have also the Data Protection Authority members in the seminar, so we could exchange with also people from Africa that they also were there, and they also exchanged their experience because they want also to launch a regulatory sandbox. So thank you very much for your attention. I share with you my contact and also the CIAN website. And we have other projects in the Center of Artificial Intelligence at the University of São Paulo. And also I would like to thank FAC, that it's the foundation that is supporting also this project, and giving us the help to do everything that we are doing now in a smooth pace. So I return the floor for Juliano, and I will be glad to answer any questions.
So thank you very much, Christina. We'll open the room for questions by the audience.
I have one question.
Yes.
Is there any opportunity for new companies participating in this project, or you already designed and selected the project?
For this moment, we finished. We have the selection, but the idea is to have another regulatory sandbox that will be launched, for example, in the next or in the other year.
Okay, I catch you.
Yes. Welcome. Yeah.
Because you mentioned the goal of creating a unified framework under SIA. So which means, what is unified framework for sandboxes, or what is the goal?
Yes.
What should this framework look like?
Yes, this is very good because, for example, okay. So the question was related with the unified framework that we are working together with our international consultants and the UNESCO, no? Yeah, and we have two ideas of a unified framework. The first one inside Brazil, because we have the three levels: municipality, state, and the union, and we are launching regulatory sandbox in the three levels, and everybody doing in your way. For example, in Rio de Janeiro regulatory sandbox on health sector, it was a sectorial. They didn't publish reports to share the insights. Yes. No, it was not.
I have a follow-up question to better understand what you're saying. In Europe, the notion of sandbox is not protected at all. So many different things are called sandbox, really. And in Germany, we are now discussing in Parliament a sandbox act.
Ah, okay.
The definition of a sandbox is and what a sandbox is not.
Ah, okay, perfect. Yes, in our
Is this
bill,
the same goal that you have?
yes, in the bill 23, the question was related to have a definition of a regulatory sandbox in a country, and if we have a unified idea about what's a regulatory sandbox. Yes, we have this idea in the bill 2338. We have a specific chapter that it's about a regulatory sandbox, and the idea is to have the definition, and it's why it's under discussion. The idea is also how to organize here in our country, and what it's needed to be the standard sandbox, because of course we will have some differences if you have, for example, a sandbox in the health sector, or for example in the urban mobility sector, but the idea is to have an idea of what's a regulatory sandbox, and maybe we could also help here with this pilot project. And I participated in the debate in the deputy chamber to talk a little bit about this, because it's a very small chapter in our bill, but they know that they need to develop it, because everybody is doing regulatory sandbox and they have different ideas. And for example, we will think about innovation in our bill. Yes, every regulatory sandbox needs to have companies that will present an innovation. So this is a requirement to our regulatory sandbox. But we have some experiences, even here in Brazil, that we do not have this requirement to participate in a regulatory sandbox. So our legislator think that it's important to have this innovation aspect, because otherwise we will be a compliance team, because we need to have innovative solutions. As I told you, we are under debating. We didn't fix this, but the idea here is to share, for example, this first report that we will publish, and share some insights to have this definition. In the Brazil, yes, want to have a definition of a regulatory sandbox, and which kind of requirements we want to have in each regulatory sandbox that we will run here in the country. Thank you for the question, because this is a very important idea here to harmonize the idea.
If I may just add one follow-up question about the cross-border AI sandboxes. So how will it work, and if there is any precedent in Brazil that you are aware of?
Yes, we need to establish a scope to this kind of regulators. Every regulator sandbox needs a scope, but for this kind we need a specifically scope. And for example, we will need to focus on transparency on AI and so on. So what we are thinking about to have a UNESCO regulatory sandbox for countries here, because some countries, for example, in Caribbean area, they do not have a structure to conduct their own regulatory sandbox. It's why it's so important this international perspective here in the region. So, for example, Brazil, Chile, and the Colombia, they are leading this kind of research. So it's important to give some support in this region. It's why we are thinking about this. But we have also other experiences, international experiences, that they want to, for example, have a regulatory sandbox specifically for a sector that is important to all these countries that will participate, as we check out in Singapore. So you have Singapore, Hong Kong, and other countries. They are testing some AI solutions that they are using together. So we have this two sides. Also, UNESCO is checking out to have a regulatory sandbox for Portuguese language countries. So then we will connect with Mozambique, Angola, Cabo Verde, and the Portuguese language countries in the region, also to give this support. Because, for example, people from Mozambique and Angola, they were in that seminar, and they told me, oh, we want to have our regulatory sandbox, but we do not have the infrastructure and the experience and the people that could help us. So let's have a partnership in order to conduct this, because it's important, because they have startups and companies that are providing this kind of services in the region. So the UNESCO initiative, it's very important.
Okay, thank you very much. So I will close this first panel. We are behind the schedule for around 20 minutes, but I think this is manageable. And we will have now a short coffee break of 10 minutes, if possible. And I will ask for the next panels, for those who are interested in making questions, to please stand and come here in front to talk in the microphone. Otherwise, our audience, our online audience, won't hear the questions. Okay? Okay, so a short break of 10 minutes. Thank you, Christina.
Thank you, Juliana, for the invitation.
Very pleasant coffee break. We'll start working again. And this panel will have a more technical approach, starting with Ana Rosa Brandão from the Faculty of Engineering of the University of São Paulo, who is also part of the project at the data protection, the sandbox on the Data Protection Authority, and we'll share some of the technical difficulties and challenges that we are facing in this project. And then later Renata Wasserman, who was already presented as one of the leaders of our project on the potentials of AI certification, and she is also professor. This is the most important thing. But she's also a professor of computer science in the Department of Computer Science of the Institute of Mathematics and Statistics of the University of São Paulo. And computer science.
And computer science, right
It
now.
was added last
Okay. And you deserve that. Okay, so I'll start with, I'll give the floor for Ana Rosa Brandão. Thank you very much for joining.
Thank you. Thank you, Juliano, for inviting me. Good morning. Well, I will talk a little bit about how can we accurately assess the quality of AI systems, because when we do research in artificial intelligence, we usually assess accuracy mathematically, and we are not really concerned about the results of our systems and its impacts in society. Why do I say that? It's because when we simply think about functionality and not necessarily knowing the law and all regulations that involves data protection, we simply give engineering solutions for real problems. And now we are in a moment that these solutions are really at scale and in use by society. And the Sandbox project, the ANPD Sandbox project, come to put light in this area, mostly considering AI systems that use huge amount of data. But let's start talking about who am I? I'm bachelor in math and law, but it was 30 years ago. I'm livre docente. I don't know how can I say this in English. In French, it's ADR. I'm the mother of Leonardo. He's a 17 boy. And I'm associate professor at Escola Politécnica da USP. I'm a researcher at the C4AI and CIAM since their very beginning. And then I'm witnessing all this evolution within the University of São Paulo. The context of this talk is I'm part of the ANPD regulatory sandbox. And as Christine already told you, it's a controlled environment for us to balance technological innovation and the protection of fundamental rights. In these systems that we are calling them AI-driven systems, there are systems that adopt AI to support their functionalities, and of course, all the results that these systems, all the outputs of these systems are AI-driven, or in some sense, they are guided by AI outputs. And sometimes, as I told you, they may not be compliant with fundamental human rights. Because first, we solve the problem, and then we witness how these solutions are impacting society. And because of that, we need to put safeguards and create some regulations and things like that. And at this point, we are talking about accuracy. And what is accuracy when we look for the meaning in the dictionary? The Cambridge Dictionary says that accuracy is the fact of being exact or correct. And the second meaning is the ability to do something without making mistakes. It's a very strong meaning for AI systems. When we have deterministic solutions, computer science, considering determinism, we can calculate accuracy in the meaning that we find in the dictionary. Otherwise, when non-determinism is included in solutions, this word has a very fuzzy meaning because accuracy cannot be an exact and static measure. Then, in the sandbox, and within all AI systems, when we talk about accuracy, we cannot think about accuracy as just a performance score. When we talk about accuracy in AI systems, we need to take the legal compliance requirement strongly. Because, as I already told you, the systems are in production. We are using these systems. And we cannot consider just accuracy as we calculate, the accuracy is 87%. Okay, 87. But is it good or is it not good? In the context this system is deployed. Then we need to look for legal implications because these systems will be more or less accurate depending on the context they are inside. And of course, inaccurate systems can violate the law of the general law of data protection in Brazil. And the most, in the most part of the times, the principle of necessity, when we think about the need of using the less resources the less data associated to personal rights to implement some system. But these AI systems use huge amounts of data. And by definition, they are not compliant with this principle of the LGBT. And of course, since these AI systems, they find patterns in this huge amount of data, they are collected in society. But depending on the sources of such data, this data bring with them all biases that society have. And since all the large language models used by these systems came from the north part of the world, this also brings some bias that we can think about and protect ourselves from the global south and think of some possible solutions. Nevertheless, there are already several initiatives related to information security. There are some normatives in Brazil. We are good in harming, but we are good on protecting also. Brazilians are knowing by being very good hackers, and then because of that, information security is a research issue. Very, I don't. The word is missing, but it's something that here in Brazil we are very good. Then the idea is, how can accuracy be technically documented and independently verified in a way that satisfies both engineering rigor and regulatory accountability? Well, since we need to be technical, we begin with technical documentation. And we already have some documents to begin. We are following the sandbox, the NIST framework, the AI risk management framework, which considers accuracy as a measure of trustworthiness, which I think that it's a very interesting way of assessing AI-driven systems regarding accuracy. And also, we have ISO standards. These standards are related to information security. As I already told you, we are very good ones in this issue in Brazil. And we already know how to protect some systems regarding several issues. And when we abstract the meaning of accuracy, we transit from metrics to trustworthiness. Because accuracy is not a fixed characteristic, because it varies across contexts and populations. Another thing that this framework considers a lot is the human judgment as for each of the characteristics of trustworthy. And if you could see here, this is I just copy from the framework documentation. These are characteristics of responsible AI. If you develop AI systems considering responsible AI principles, you already have all this in consideration. You take this in consideration. But we need to train people, to educate people to develop responsible AI systems, because they are not prepared yet to do so. Now, what we have are software engineers developing AI systems using the frameworks they already are used to. But complexity is increasing a lot, and to considering this kind of characteristics from the very beginning, we need to educate people, developers, to design AI systems, design responsible AI systems from the very beginning. Okay. And then, just to talk a little bit about what we are doing in the sandbox. We are following these frameworks and taking in considerations several issues they are stating, but the human part of assessment of the two of them, maybe the three of them, but two of them, we are using the RPA survey. RPA survey is a part of a huge platform that is called RPA. RPA is a bird in Brazil, a huge bird in Brazil. And because of that, it's the bird. All the models here in Brazil, they have names of birds, and then we follow this. And the RPA is a platform to support assessment for large language models. Several tasks related that are performed by large language models. And the RPA survey supports structured human assessment of LLM. How we implement it? It is a Moodle plugin. Moodle is an learning management system environment to support learning and education. And inside Moodle, we already have means to provide assessments to students who use the systems. What we did, we reuse this part of Moodle and include them a way of providing assessment for large language model tasks in a way that it's replicable and reproducible. This can help the users to have a better experience, and the specialists in evaluating and assessing if the results the system is giving are good or not. At this time, we will begin in the next week this part of the tests where the specialists in each contest, remember that accuracy is contest related, and in the sandbox, we are just starting the next week. The tests that we will use are RPA survey with specialists. Then the solutions have outputs that will be evaluated by specialists concerning their quality. And by using that, we are thinking about a measure of quality of the solution provided by the applications. Since Christina said that we have three kinds of applications in different levels of technology readiness levels, and because of that, and for each cycle, for the first one, we will have specialists, and then we will maybe suggest some changes. In the second run, we will have another time a specialist, and in the third one, we will have users, volunteers, to give their assessment. And this will be an evolving assessment of the accuracy of the systems. Some lessons. The sandbox is really a space of co-creation. I'm learning a lot in this project. And we have people from law, we have the researchers, we have people from the industry, and we are building something together. We are learning what kind of problems and what kind of solutions we can find, because all these systems are in the edge. They really are innovative. And since AI systems are already widely adopted, it's really important that this sandbox have some adaptive pipeline at the end as a protocol for people to who wants to be compliant with our ANPD laws, regulations. And that's it. Thank you. Falei mais de 20, né?
So, no problem. It was excellent. Thank you. Now I open for questions from the audience. Yeah.
I didn't quite understand. Maybe I need the mic.
Yes.
Yes, you need it. No. So maybe if you can.
You can come forward.
Yeah.
Yeah.
This one, the wireless one.
But it's working.
Not working.
Yeah, it is. It is working.
No, it's not.
Should be.
It should
But
be.
it should, but it's.
Yeah, yeah.
Thank you, thank you. Very interesting. So I didn't quite get the reproducibility of your setup,
Yeah,
which involves human stakeholders.
yeah.
The humans are not reproducible.
No, the human are not, the experiment are reproducible.
The experiment is set
yeah,
up.
the
is-
setup, yes,
Okay.
yes, yes.
Okay, but
yes.
whatever happens, happens, right? I mean,
Yeah, whatever happens, happens. But we export all the relative, and this could be reapplied the same
Yes,
if
yes.
if we use the same. But if even if the volunteer is the same,
that's sweet.
and the next time he can or he or she can give another answer or another kind of now I think that it's better, but in fact it's the same. Yeah. Okay. Yeah. That it's okay. Yeah.
My question is, you said that you are evaluating LLMs in different areas.
Mm-hmm. Verde.
Ele desligou, parece.
Fala aqui. É tua mão, hein, Rafael? É tua mão. Foi na tua mão. Rafael não falou nada. Foi na tua mão, cara. Nada disso. Ó, usa aqui, ó. Você tá aqui na frente.
So my question is if you are evaluating, because LLMs are being used in a variety of different legal tasks, including drafting judicial decisions and by lawyers and so on. If you're evaluating benchmarking this kind of tasks, if there is anyone thinking about this in RPA.
Not this kind of, but we can think about if you want.
Yeah.
If you are interested, you are welcome. Because Sarah Jane has a student who work with some law-related issues, and then maybe we can do something. You are welcome, really.
Okay, thank you very much. And we move now to Renata, please. So Renata, the floor is yours.
Let's. I like to move while I speak, so let's see if that if I don't fall. So, if for those who got the program, Juliano had put a title. It's my fault, actually, because I forgot to tell Rafael what I was going to talk about. And then Juliano made up a title that I would talk about how to make systems non-discriminating. And, well, then I changed the title a little bit. Can we do that? And, well, my short answer is I have no idea. And I was puzzled by the title he gave because I've never worked with this. But I have some guesses, and I've been playing a bit with the idea. And I think it depends a lot when we ask this question, what we mean by checked, by non-discrimination, and especially about AI. So I started stepping a little bit back and said, okay, so how do you define these things? And if we start with AI, there's no consensus even about what is AI. So I put here a very old traditional definition by John McCarthy, who created the name artificial intelligence. And he said, well, the science of engineering intelligent machine, making machines more intelligent. Yeah, what does that mean? And this is part of a question-answer session. And the next question is, okay, what is intelligence? And yes, no one knows. So if you take, this is from a traditional AI textbook, so Russell and Norvig, they list their maybe a dozen or a bit more of definitions from other textbooks, and they are all different. So what AI is. And they basically, they make this, this classification about whether we want to behave as a human or behave rationally, which are very different things, as we know. And whether we are talking about thinking or acting. So these are different things. And which AI are we talking about? Nowadays, when we talk about AI and regulating AI, we are talking basically about machine learning, generative AI, especially. And it strikes me sometimes we go, for example, Cristina was talking about the Brazilian plan for artificial intelligence. So I was there in Brasilia 2 years ago in the ministry. We had this discussion about how to make things, so the Brazilian strategy for AI. And then there was this person that spoke just before me and said, oh, you know, I've been in this field for more than 5 years, and I've seen everything from the beginning. And I was like, what? And I come from symbolic AI, and at that meeting I realized that most people didn't know what that was. And this was mainstream AI in the 80s. And I took this picture. The years here are wrong, but if we look at artificial intelligence, it's much more than machine learning. So machine learning is part of it. Deep learning is part of machine learning. And generative AI should be somewhere here, a small part of it. So whenever people are talking about AI, they're thinking about data-driven AI. And as this became to be, this started to be the mainstream AI. So until the 90s, mainstream AI was symbolic AI. So expert systems, people were coding rules manually. And this is when I started studying AI. But then, okay, nowadays this is mainstream AI. And 10 years ago, this book came out because 10 years ago, most of the people, the real people in the world, not the computer scientists, were not aware of artificial intelligence. So that's why someone that says that worked for 5 years in the field thinks this was the beginning, because this is when it became popular, that everybody started talking about it. But 10 years ago, there was already this book showing the bad effects of this machine learning, so this data-driven AI. And if someone hasn't read it yet, I highly recommend it. There are lots of examples of how this can harm people. And this relates to the discrimination stuff. So we know that just big data won't work. And talking about things that don't work, I like this. So this was just after Elon Musk. Yeah. Well, the baby was not inside, so the trolley was in the back of the car. But yeah, you see what happened. So yesterday, I don't know if I can pronounce your, but you mentioned the autonomous cars, and I think, yeah, as a computer scientist, I wouldn't trust one. And if we go back in history, so this is a famous paper for symbolic AI people by Bob Kowalski. This is from the late 70s, saying that algorithm is logic plus control, and that you need to have the logic clear. And this is the main problem when we look at all these new tools of AI. You don't know. The algorithm is not the problem. The algorithm is just taking data and producing something, some model, some mathematical model. The problem is that the logic of what this is doing is not clear. And then there's some, well, several people mentioned already, there's for these LLMs to work, there must be some random part in it, otherwise they don't work well. And if there's some randomness, then you just cannot make sure that bad things won't happen. So for me, it's already a point. But then, what can we do about it? So for machine learning, data science, so data is power. The more data you have, the better you are. And then you have all these companies chewing all this data in the world and producing things that are so expensive that only these 5 big techs can make it. But then, what is data? So data, this is an example of a real project on health, and this is data we get from the Brazilian National Health System. And you get this data, and what does it mean? And I was in this project together with people of the public health faculty, and what happened was I was leading one of the AI teams, and there was someone leading the other AI team, and we were doing symbolic. We spent almost a year trying to make the people understand what we were doing, and 2 years to understand the data. And the people on machine learning, they had results in 6 months. They called everybody for disclosing the results. And the new knowledge they had was something that every physician knows. So they discovered the most important variable to predict child mortality. And when they mention it, so the people from the public health were looking like, what? You used all these machines, just open a textbook. So it is important that for symbolic AI, it's not data. it's the knowledge. You have to know what you're talking about. And what we do in symbolic AI nowadays, the most trendy part, and I'm working with this, and Hausa did as well. So we are talking about ontologies, so ways of describing symbolically what is going on with data, with concepts. So what are the important concepts? So you have a disease, and then you explain a disease in natural language, but you relate it to other terms in other documents, and you can list the different diseases, and you can write when an infectious disease is viral or not. And we have all sorts of ontologies, and especially in medical, in biomedicine, we have loads of ontologies, and working with ontology, it takes time, but it is the only way to make sense of what is going on with the data. So, and if you're talking about medicine and law and all this critical stuff, or sending astronauts to the to the space, you want to make sure that your system works. And it doesn't matter if it takes 5 hours to prove that it works instead of 2 minutes to give an answer. Who cares? You're spending billions. You want to make sure it works. So just to give some time ago when I talked about ontologies, people said, okay, this is academic, this is academic. But now we see more and more examples. So a student just showed me this, so not advocating for Palantir, far from me, but one of the largest AI companies working on defense, they have ontologies, so the symbolic knowledge as the central system for orchestrating decisions. So the thing is, it's not that we throw away machine learning and all this stuff, but if we want to have some control over it, we need to mix both things. So we need to have the symbolic level as well. And most companies are starting to realize this. And some years ago, it was hard to get students to work in symbolic AI because they say, okay, this only exists inside the university, there's no jobs. Now they are all landing in these highly paid data science jobs because the companies need someone that can describe what's going on in the systems. Well, how does this relate to discrimination? If we look at these two different kinds of, so machine learning and symbolic knowledge, usually we look at it either using this black box system that learns from data and creates something, or we use expert knowledge. So we go to the doctors and ask until we find the right definitions. But we should use both. It's not one or the other. So in my view, we have to use the expert knowledge in order to control what's going on. I don't know whether we can do, if it's feasible always, but this was also a point. I was with a colleague. We were heading this committee for diversity and inclusion in the Center for AI. And we were invited to an event with OpenAI. And there was one person from the technical area and one person from the business area. And of course, the first thing my colleague asked was, how do you deal with discrimination? And how do you deal with racism in ChatGPT? And they say, oh, now we have a department for dealing with it. I said, okay, but how do you deal with it? And they say, oh, when someone marks something and is discriminating, we send to this group. I said, Okay, and what does the group do? Nobody could explain anything to us. And then I was very shy there, and I asked, have you ever thought about adding rules of things that should never be said? And they looked at me like I was coming from another world. And they said, no, we try to train again, and we do this and that. And I was like, maybe you can impose something. And I think this is the way if we want to talk. But then there's this thing that in order to use expert knowledge, we need expert knowledge about what discrimination is. And this is very far from an easy task. So it's very, very far, very hard to make it explicit. We can use some humans. So humans are sometimes good in marking something as discriminating, but not always, because discrimination can be so many different things. And how can we define this? And so many things are cultural dependent. So my point is, okay, we are very far from having control over discrimination in AI systems. We first, if we want to put a symbolic level on top to control things, we first have to discuss very carefully what this means. And here I think the lawyers have more experience. We have things here in Brazil, like laws against racism and several kinds of discrimination. But they are not always very explicit, so things are left very much to a human to judge in the end. But at least is a starting point. So there's no real conclusion. So my answer to the first question was, okay, we have to think carefully about it. It's not just that we can switch some of the parameters of a model and then suddenly it won't be racist anymore. So, thank you.
It's okay. So so thank you, Renata, and I'll open the room for questions by the audience.
Lunchtime.
Yeah.
I have rather a remark than a question, since this your last point, your last invitation to define what discrimination all is about. That reminds me the last project that I had together with Holger Hermanns and some philosophers. Because once I gave a presentation on discrimination by AI, and the point where we couldn't agree at all was what discrimination really is. Since it's well known now, technicians have a totally different concept of discrimination. For them, distinction and discrimination is almost the same. While for a lawyer, it has a totally different, more narrow meaning. That's well known now. So for us as a lawyer, the question is what a reason is. And that was the point we couldn't agree on, because does it imply intent? And I said, yes, according to the legal concept of discrimination, it requires intent, because otherwise you cannot motivate you if you don't know what you. And that was the point where we couldn't agree at all, and we have to do further research on. Can you make a discrimination for a reason without even knowing it? And that has not been established in law, because so far, for a human, we think that the human would know what he's saying, what he would know why he makes a decision, and if he cannot establish that knowledge, then we don't establish discrimination. So this is a core point for further research, definitely in the field of discrimination by AI, since we have the same problem, this black box, and the question what knowledge is really means, what means knowledge and intent in a case of an AI system making an assessment or decision. So thank you very much for putting the finger into this point.
Thank you. Yeah, I agree. It's very hard, and this question of intent. So we usually judge things based on how people act, and if we want to talk about systems in the same way, I mean, what is an intent there?
Yeah, I think this is a very challenging point in the very effort to connect two different domains of knowledge, the legal and the technical one. I will talk a little bit about this in my presentation, but this is typically the challenge. Usually, jurists, they use technical language by definitions which are mostly concerned with legal consequence. So what's discrimination has to do with a legal concern on some abusive distinctions for minority groups. So it's different from having distinctions or classifications, because in any event, all AI systems are about classifications and predictions based on these classifications. So the AI is systems, the data systems are driven to find distinctions and establish predictions about these distinctions and some patterns. And these definitions, by these legal and technical specifications, these legal specifications are actually intended to be applied by humans, by judges that are going to evaluate contextually what these definitions would mean, what is an abusive discrimination in terms of racial discrimination, in terms of gender discrimination, and etc. But this evaluation is subjective by so that we empower someone, a human, to provide this subjective classification or evaluation, which is highly contextual. And now we are asking computer science and engineers for testing AI systems. We are asking for metrics, and judges do not work on metrics, based on metrics, but based on subjective evaluations. So how to turn these subjective evaluations into metrics? It's really a general and very difficult problem that we are going to face in trying to design these certification frameworks.
Yeah, I was just going to say that when we talk about intent of an AI system, you have the intent of the person that created the system. You have the intent of the people who created the data used to train the system, and the intent of the user that is producing. So that there are so many things.
Yeah, and then you have, well, it may, there are two different concepts in the legal domain for discrimination, which is direct discrimination or indirect discrimination. Direct discrimination has to do with intent. You design a system to provide a discrimination which is only problematic if it's an abusive discrimination. So deal with that by metrics. And then there is the indirect, which has to do with some possible discriminatory effects. And again, effects that are abusive against minoritized groups. So it's really hard.
I appreciate the discussion, but I find it a bit focused on the word discrimination. I mean, in the legal discussion, there's also the word bias, there's the word fairness, and I'm not sure that they also need intent. right? I mean,
No, there is this aspect of direct discrimination would be intentional discrimination, and they surround this also words of which are used by bias, or if it is fair. It's fair has to do with, are there reasons for this distinction that is being made. This regards already that we are facing the concept of what is an abusive distinction. Discriminate is not only make distinctions, but abusive ones. They are abusive if they does not have a sufficient or fair justification. So the lawyer is always using these concepts. And it's not having a justification, it's having a fair one. So you can specify, narrow it, and find some ways to approach the problem, but you always have some room for subjectivity. And that's why designing metrics is so hard.
May I just reply to Holger? Holger is making the same point as he did 2 years ago when we had the same discussion. And I still want to ask, can you be motivated by something that you don't know, that you don't have in mind? This is just the question. And the techies would say yes, no problem, but I doubt, from a legal perspective, I doubt.
Let me get concrete here, and I hope this is not something that I'm doing 2 years ago, that I did 2 years ago and I do all the time. So let's assume we are developing an app that tries to do skin cancer recognition, okay? And then we have to select pictures of skin cancer, and then someone does the selection, and whether on purpose or not, he may overlook certain skin colors, right, relative to the distribution of the skin colors in the application context. So let's say if it is, let's say for Finland, then a good skin cancer app should have a representative skin color relative to what you find in Finland, and different for Brazil, I would say, right? And it should be obvious that this is a design goal, and then whether or not intentional, if it is then done wrongly, I would say, then this is a professional oversight that then leads to, in a sense, discrimination or unfairness, because the risk that certain skin colors are badly treated and therefore give you wrong results is of concern. No? You don't like it? Okay. Okay. You like it?
You can give him the mic.
The system is poor. And if someone gets cancer just because the system is poor in the sense that you describe, he or she maybe have a claim for compensation. But it's not a discrimination, and there's no fine for discrimination. This is to be understood. This is just a poor performance. The system shouldn't be used just because it doesn't perform well. It doesn't meet the required the quality requirements. That goes without saying. And still, the management may be liable for using such system and not doing this oversight. But this is not a discrimination case.
I believe that we are not going to have frameworks that could solve these issues purely with technical metrics. So actually, the certification of AI systems must be complemented by organizational governance methods that involve humans, because it's not only about deriving some technical metrics that may be accomplished, but in the end, the system must be evaluated by humans in the loop, and so these technical I mean, informatical solutions should will have to be complemented by this checking within the structure of an organization that is responsible for the system. Actually, when we were designing the project, Georg and I, we initially thought about exploring the potentials of AI certification, not only the technical certification of the system, but also certification of organizations. But then we concluded that it would be too much. So first, let us deal with certification of AI systems and bring about problems and solutions. And then let us think about organizations, because in the end, we will have to complement these both methods.
I think this gets back to the problem of AI literacy, because you cannot control the systems, but if you let people know what can get wrong, then people can decide whether to use it or not. But if you don't have, and yeah, most people don't know how things work and don't want to know the details, so it's hard. So that's why AI literacy always comes in the play, and but how do we get it? You know, you sell a pack of cigarette and it's written that it's bad for your lungs, it can cause cancer and everything. So maybe there should be this kind of labeling in the AI. Yes.
Okay, so we close this panel and we meet again at 1:30 here. Okay? So it's a lunch break now. Thank you. with the activities for this afternoon. We'll have in this panel first an introduction and debate about promises and challenges for AI certification, where I have also changed, Renata, the name of my presentation also. And then later, right after, we are going to discuss some aspects related to environmental certification and specifically certification for green AI. So, my idea now is to discuss what are the promises of AI certifications and what are the main challenges for AI certification. And I will also bring into some perspective the European in comparison with the Brazilian approach as it stands in the present text of the draft bill on AI law here in Brazil, which is now under debate in the Congress. So first, let us discuss a little bit the promises of AI certification. So the main advantage that we may list for proposing an AI certification scheme, which is I mean an AI and private AI certification scheme as a tool for AI regulation, is that the first one is that we reduce the costs for the state, not only to regulate, to providing the standards, but also to check conformity. So it's a sort of enforcement that you delegate for the private sector, which has, and this certification schemes as a private enforcement system has some advantages that we may highlight. First, expertise. The development of the AI systems and the technology usually comes from the private sector. So we can organize and bring together the private actors which retain the knowledge and the state of the art of the technology. So if we leave the standards and the specification of the standards for implementation for AI risk management, we may have the codes of conduct and also the enforcement through methods for verification. Also, there is the advantage of flexibility. Publicly or criteria or standards that are proposed or published by the state usually are less flexible because you need legislation or you need procedures by authorities to specify these standards, while in certification, private certification schemes, there's more flexibility for change and keep the pace with the development of the state of art. Regarding the enforcement, the private certification is also continuous because it will be constantly and also not only constantly checked by the certification organisms or organizations, but also it could reach a greater number of agents that are implementing compliance with AI regulations, and then can then obtain the stamp and the certification. And the other aspect is more polemic, as if it's an advantage or if it's a disadvantage, which are the incentives. Certification schemes and programs, they try to bring commitment with the practice or the benchmark and the standards in an industry through providing prices. So the stamp is a price that may bring a market reputation. On the other hand, one may question that reputation is not enough, and I will discuss that later. Actually, this, as I see, this is contingent to the fact that it depends on how the market will react. If the market really attributes as reputation of AI or responsible AI a market value, and it definitely evaluates them as some positive or even a condition for doing business, then certification will open room for more business opportunities. But it depends on how the market will react. And of course, supervision and validation of the system by the state is a way to enhance this incentive to join certification programs. So actually, whether the degree of commitment, of the strength of the commitment provoked by certification schemes for for producing conformity, whether it's a positive aspect or it's a difficulty, it depends on how the market reacts, but it also depends on how the state will supervise and validate this mechanism. So what is the industry perspective on that? We promote this forum on AI, which is called the Fórum Brasileiro de IA Responsável, which is the Brazilian Forum of Responsible AI. We have we meet regularly every month, once in a month, where we discuss standards, we discuss the regulation and the challenges by the industry. We have representatives of different sectors of the industry, and actually the debate on certification was stimulated during our meetings, and it resulted in a document that we have sent to the Senate defending a model of regulation intensively based on certification. And the reasons why the industry was defending and supporting regulation based on certification are the following. The main aspect that they would found attractive on AI certification program, besides reputation, as I said, this is also something contingent, but what they value the most is the possibility of having a relief of sanctions for administrative sanctions, and also relief of liability before the judiciary. So this is what they presented. They would bet and join certification programs mainly if they would have these benefits. Reputation is emphasized as something important, but most importantly is to have a relief. That means that the private enforcement of this certification program would be effective and acknowledged by the state. Otherwise, they would invest in all this program, and they would have no acknowledgement and recognition by the state. It would be that a waste of investment, of money, of training, and of time. They believe that the certification program through private codes of conduct and enforcement would be more reliable than state enforcement. But probably this is maybe a characteristic of our reality here in Brazil, where there is some doubts regarding the efficiency of the state to enforce an AI regulation. And they also support the certification program to the extent that this may stimulate new new business opportunities. That means you may create a market of certification where companies could enter into this business, could attract experts to perform this enforcement and control of the certification standards. And this is something that really is an advantage if we compare with the capacities of the state to organize an authority that really attracts experts, not only legal experts, but also technical experts in the technology, because of course the payroll of the industry for these experts is much more attractive in the private sector. So it's difficult to attract these staff for official tasks in the government if they are much more well paid in the companies. So these are points that were raised by the industry in supporting what would be a response, a certification program. And this is just to illustrate why there are doubts and questioning by the private sector about the capacities of the authority. For example, to have an idea, if you take the budget of the AI office that was created by the EU AI Act regulation, it's 46 million euros. Then you have the European Data Protection Authority with 24 millions, and the European Data Protection Board 8 millions, totally 80 million euros for the authority to regulate and enforce these AI standards, and also standards for data protection. The Data Protection Authority in Brazil, which is the authority which is chosen and to be the authority to enforce the Brazilian AI Act. It was initially the Data Protection Authority. Now there was a shift in the regulation to empower also regulatory agencies, because the Data Protection Authority has a budget of 3 million euros in comparison with 80 million euros. So there is a limitation to equip the authorities to make this enforcement. So that's why in Brazil the industry likes the idea of having full and robust certification programs to provide the commitment with the best practice in AI risk mitigation. Well, then reasons for promoting, another reason for promoting AI certification programs is that the legislation has provisions for it. So the EU AI Act has provisions for certification and validation of AI systems. There are rules concerning mandatory certification for high-risk systems, but there is also voluntary certification for AI systems which are non-risk. And particularly this is something that we are exploring in our project. In Brazil, there is also one chapter concerned with accreditation of certifying entities and certification. And the Logarithm Association, particularly the Brazilian Forum on Responsible AI, was particularly influential in this respect. We have prepared a full contribution for the Senate, proposing a regulation which was only based on certification. It had no, it attributed a role of only supervision for the state, and the whole private sector would provide the specification of the standards and the certification program as a means of enforcement. It's important that in this program, what will be certified, what will be not only AI systems, that means the softwares, but also the developer, the operators of the systems or organizations, but also users, specialist users, and the super user. A specialist user would be the user who is specialized in the domain of application. For instance, a physician for softwares that are applying to the health sector. And the super user would be that user that domains the AI technology. So we could certify users, operators, developers, and softwares. And the idea to have different stamps for these agents, one stamp only for transparency and one another advanced stamp, was to not to create barriers to entry in this market. Because if we have too strong, a very restrict certification program where it's difficult to access these stamps, we may hinder possible entries in this market. So the idea was a progression where you could certify your software, you could certify users, you could certify organizations, and increasing your degree, your reputation as a responsible company with responsible products. So it achieved not only it was not only a product level program, but a product entity level program. And then the main incentives in this proposal of legislation were reliefs from administrative sanctions. Of course, we could not regulate how judges would decide the liability issues, but also being certified would be a condition to take part in public bids, not only for receiving investments by the state, but also to on bids by the state to acquire software. So these were the main incentives, and it was the proposal was incorporated to some extent. Of course, our proposal would be to base all the legislation in a private certification program. This was not the decision by the Senate, but they incorporated a chapter on certification. They didn't include, though, these incentives that we have proposed. So what the rules means is that there will be, the state would accredit certification entities, and this accreditation, according to the legislation, is given by the Data Protection Authority as the AI authority, and also the sectorial regulatory agencies. So they would accredit these certification entities, and these certification entities would then provide acknowledged and certifications validated by the state. It could be according to the rules, not only for softwares, but organizations, etc. But they didn't incorporate the main incentive, which is relief from sanctions, and also the participation in public bids. But in any way, this can be then further regulated. The possibility is there, so it's just a matter of organization of the private sector in different sectors of activity to organize to create their own certification programs. Of course, when the law becomes approved by the Parliament. So another one may ask, but in the United States, which is a very strong player in this field, there is no incentives or no talk about certification, while Brazil and in Europe are producing and working on standards for certification. Well, recently was published this is the last issue of The Economist, and there is an interesting discussion about this Mythos moment. Mythos is the release of the Anthropic LLM who has proven to be quite efficient in finding failures on software and then to be a tool for cyber attacks. And it was so powerful that the developers decided not to release them for publicly, but to release them for 50 companies in order to prevent the tremendous risks that would be unleashed, that could affect national security, that could affect health systems. And this provoked in the US government a new stand regarding regulation. So initially, particularly the Trump administration is against regulation and defend a laissez-faire view of regulation. But now, not only this episode, but also the episode involving Anthropic and the Pentagon, where Anthropic refused to to make available softwares that would support some features of autonomous weapons or vigilance systems. The U.S. administration became aware how powerful and how great can be the impact of these systems for national security. And now there is the understanding that there should be regulation to some extent. On the other hand, regulation and also responsibility has the cost of reducing efficiency. So efficiency of AI systems does not produce responsibility. Responsibility is another layer that may brings limitation to efficiency. And the main concern is if we over-regulate, then this may hinder our competitiveness, the U.S. competitiveness in this field, particularly in their race against China. And this would then make even more dangerous the threat that AI brings to national security, because it's one thing if American companies are producing these systems that may be a problem for national security, and another thing is these are Chinese companies. So to the same extent, there are several pieces in this volume, in this last issue, where they discuss this. On the one hand, they must regulate. On the other hand, they cannot hinder, because then the threat to national security would be in the hands of foreigners, particularly China. So what are they seeing as a possible solution? Certification. Because then private certification could come into this scenario and have a more flexible regulation that might not hinder efficiency, and on the same time could make some controls and checks for dangerous softwares. So this is the part on the promises of AI certification. Now the challenges. Well, the main difficulties, I have made a list, but probably there are more. We are digging into it. But one of them is the legitimacy concerning public interests. So if it's a private arrangement and a private program that would probably be developed by sectorial entities which represent the industry, then there will be a concern that actually the certification is protecting commercial interests of a particular sector. So there must be procedures that warrant the independency of certifying entities, the impartiality of these entities, and also that have due process so that companies willing to obtain a certification could discuss if their conformity is correctly assessed. Another challenge is how to, in this arrangement, how to combine, to provide legitimacy concerning public interests, how to combine the private arrangement with state supervision, how to ensure that the success of the certification in the eyes of the state, how can you have mechanisms to obtain this control by the state. Of course, the whole procedure would be structured and developed and operated by the private sector, but there must be some interventions by the state that make it possible to control the success of the program, to ensure commitment with the best practices of risk mitigation in AI. So the discussion about risk reputation I have already gone through. There is also the problem of vagueness of the standards, and this is one of the main objects of our concern in this research project, how to deal with vague standards and how can they be specified in order to be implemented. There is also the problem of lack of uniformity. If we opt for private programs of certification, and if this becomes a business, and it's important that it becomes a business so that we have companies that will invest in experts to make the auditing and to provide the certification. There must be a market, but on the other hand, if you have too competitive market in the sense with many players, there will be a problem of uniformity regarding the standards. And this connects with how the state will supervise these programs and the certifying entities. There is also a difficulty regarding transversal versus contextual criteria. There are some criteria that may apply to the whole to many different sector of activities, to medicine, to the judicial system, etc. But there are standards that would only make sense, that could only be specified for a contextual or a sectorial activity. So standards for health may not work for instance, standards for transparency regarding health or precision may not work regarding the judicial system. So this will demand from certification programs the ability to deal with technical and general standards that demands AI expertise, but also standards that demand domain-specific expertise in the health sector, in the judicial sector, in engineering sector, and etc. So the programs has to deal with this difficulty. And also the compatibility with international standards. There may be standards that are global, but there may be standards that are local. I will give quickly some examples, and I will leave it for our last panel because I have already used too much time. And another problem are the entry barriers that a certification program may create. So it must be a program that is accessible to all companies, particularly to small companies and startups that are entering this field. Otherwise, the field will be protected for the incumbents and the big firms that are already providing solutions for the market. So, and how would this a certification program ideally look like? Well, it must be convergent with the legislation. And in this respect, regarding uniformity, we have the advantage that the European Union has provided and has been a pioneer to provide ethical principles and general standards that became, at least in the abstract level, that became standard. So the high expert group in Europe that provided the first document in 2016, if I'm not mistaken, has influenced the whole debate on the ethics of AI. And it also, if you check the Brazilian legislation, it is basically concerned with the same principles of risk management. So human oversight, robustness, safety, privacy, transparency, and the model of protecting fundamental rights. Also, not only fundamental rights, but the most recent debate, we are going to talk about it, is also concerned with environmental issues and impacts. So given that we have legislation, and the standards must be, of course, convergent with these obligations present in legislation. And we have, for instance, in our research project, we are mostly concerned with these three entities: ISO, IEEE, and NIST. And according to these standards, we have many chapters according to the risks that are dealt with in the legislation and in the obligations. So transparency, reliability of the system, non-discrimination, etc. And for each of them, we would have different subject matters for transparency. Transparency about use, transparency about the data, etc. and etc. And reliability, we are thinking about precision, recall, robustness. There are different issues in each of these risk types. And we have to think about how are the means of compliance, but also how to check the compliance. And there are processes for checking these compliance programs, which are related to that first issue. They must be independent to be reliable. They must be impartial. They must give opportunity for appeals, so must follow due process. It must provide for means of documentation so that it can be checked. There must be criteria and metrics, and this is a main difficulty, as we have already started discussing. But it also involves providing algorithmic tools for checking, because considering the ubiquity of AI systems, it will be impossible even for it will be impossible for a central agency in the state to make all this control. It has to rely on private efforts. But even the private efforts will not be able to do it without AI and without algorithmic methods. So there must be room for investment in these tools. That's why creating a market for certification is important, so that we stimulate investments to make it more efficiently. And then there are several methods to develop not only these processes, but the documentation, the criteria, and also the algorithmic tools for checking such compliance. There is also an important issue, which is the best approach for certification programs, because there are mainly two basic approaches. The one is certifying by testing. The other is certifying by credence, by creating trust. And it depends on the type of product and service that we are dealing with to define which is the approach. If we are talking about quality, specific qualities of the product, this is more congenial to testing. So we are going to test the quality of food. We have some samples, and we test if some nutritional items are present or not. The durability of some tools, or the frequency. For instance, in telecommunications, if the frequency is adequate, we can test the product. But if we are talking about externalities of the product, and this is exactly what is at stake with AI, the risks that AI pose to environment, the risk that it poses to fundamental rights, then we are more congenial to credence approaches. And also, when we talk about the capacities of an organization, we are more congenial also to credence approaches, where it is important to structure and train the institution and document the measures so that we can trust that the best practices are being implemented to mitigate risks. Regarding AI, there may be opportunities for testing. For instance, testing the performance and in the previous panel, we have discussed about the difficulties in testing the performance of these tools, and for instance, the level of energy which is used in development. So this we can measure, and we may test, because these are aspects that can be tested in the product. But when we talk about the training procedure, where there was diversity in the team, did they follow the aspect to protect the private, cybersecurity, etc., then we are talking about credence mechanisms. And also about the use of AI system after deployment. So this is something that decisions must be made about. About uniformity, as we have seen, you can map the main concerns and obligations between the EU AI Act and the Brazilian bill. They are more or less convergent in the main demands for risk management. So this enhances uniformity. On the other hand, as we have said and already discussed, both documents bring several vague terms and evaluative items. So we make demands as far as technically feasible, or whether some system is adequate. It has appropriate statistical properties, appropriate levels, and this must be specified. So we are not sure if the specifications in Europe will be the same as the specifications in Brazil. What we can appeal to in order to have more uniformity is so I thank Gabriela for this slide. I took it from the presentation yesterday. We have the international standards for bringing uniformity. If both Europe and other legislation seek to make specifications that are close to international standards, so we may obtain uniformity. However, Europe and Brazil are following different, at least in the present state of the Brazilian draft bill. We are following different directions. While Europe is more centralized, not only having a central authority with empowerment for implementing transversal obligations, the Brazilian AI Act has made a shift to a sectoral approach. So we may, and the specification of the standards will probably be implemented by sectoral agents with an expertise of the domain of application, and sectoral entities, private entities that are representative of different industry sectors. So we are probably going to a more sectoral than transversal approach. Then a few difficulties that we may leave for the final rounds. The first one of them we have discussed in the end of the second panel with is metrics for legal concepts. There is this basic difficulty that legal definitions are driven to deal with legal consequences in terms of responsibility while the technical stuff is more related, the technical approach is more not having distinctions or different classifications. It's about abusive discriminations, as you have discussed, and how to create metrics for abusive discrimination is quite difficult. This is, for instance, from a paper that I'm suggesting here, where there is at least 20 different metrics for proposed technically for to measuring discrimination. Is this adequate regarding legal definitions? This is an open debate, and it creates a basic difficult. Discrimination is only an example because it appears in documentation. If the documentation is sufficient, is the level of reliability is appropriate. So all of this we have to discuss. So global versus local is another difficulty. I will leave this item for our last round because, for instance, reliability metrics brings an example on brings an example to discuss if a global criteria is appropriate as a metric of reliability, because there are local issues that may demand different evaluations of the very same metric. And regarding transversal versus contextual standards and specifications of the standards, transparency brings an interesting example. You may take a look and scan this paper, which is a paper where I have developed with colleagues methodology to a methodology for the governance of transparency in law courts, and we have identified different recipients of information about about an AI system. So there will be 6 possible recipients with 5 different objects. The use transparency about the use of AI, about the data, about the model, about the interaction between human and machine, and transparency about the risks of the AI system. So we had 30 informative context, and since we would make 4 questions. What is the object? Why should we be transparent? When and how should we provide the information about the systems? We would have 120 specifications of information that should be provided about one system of AI applied in law courts. So if we go through the domain of application and would like to have all this specification of standards for transparency, the degree of the detail will be very specific. So is it possible to have transversal standards on transparency? It's not clear yet, and this is a challenge. This is just an example of the matrices that we have developed for specifying the content of information for the systems used in the judiciary. So I have pointed out some of the challenges. Of course, we are still digging into it, and I hope that in our next meeting that will be in the next year, we will have some solutions for these challenges. Okay, thank you very much. Okay, so we are going to move to Vanessa Ferrari. I give you the floor, Vanessa, to talk about certification in the environmental field. Okay, thank you very much. You still have to put your presentation.
Sorry, I'm waiting for my PPT.
Yeah, we're still waiting for the slides.
Acho que não chegou ainda.
Não chegou ainda.
Thanks so much. Hello, everybody. Good afternoon. Thank you so much. I'd like to start. Thank you, Professor Juliano Maranhão. He was my teacher, my professor, and during my thesis, my preparation to my thesis, and my special congratulations on the choice of topic. The environmental dimension of AI could not be more timely. And my first point is talking about this expression, artificial intelligence. Because you have here two foundation mistakes. First, is not intelligence, definitely not. Is statistical pattern recognition at massive scale. Remarkable, transformative, but not thinking. This is the first point. And the second one, and this is what matters to us today, is not artificially. AI is not material. It's mineral extract from mines, the water drawn from aquifers, the electricity generated by power plants, many is still powered by coal. And why does matter to lawyers? For one reason, language organizes what the law sees. And what the law not see, the law does not regulate. This is an important point. Then the material vocabulary of AI used to say the cloud, virtual intelligence, produces a legal blindness of physical externalities. This blindness is not accidental, it's constructed. And it has a name. I used to say it is the illusion of green. So artificial intelligence is now the new chimney. It's not visible smoke, but it has a carbon footprint. It has no dirt on our walls, but it has lithium extract from fragile ecosystems. It has no factory floor, but it has data centers that consume as much energy as entire cities, but has data centers whose energy consumption revolves that entire cities, like I told you. And this maturity is what makes Brazilian environmental law relevant to artificial intelligence. And then I want to offer you a tease. And my tease, my point, is that Brazil does not need the new legislation for the environmental certification of AI. And to understand why, let's look at Brazil framework. The conception and legal framework we need, was written in 1981. To be exact, in August of 1981. Before the personal computer reached a commercial scale, before the internet as we know it, and before any jurist anywhere imagined neural networks. Look at the Brazilian National Environment Policy Law, the very famous Environment Law 6938 of 81, very famous for us, contends with remarkable foresight the conceptual language we now need to govern the environmental dimension of AI. And let me show you what I mean. If you'd like to go further about the environmental law of 1981, the QR code could you link you, and the same about this research about Brazilian oil spill. We have the QR code if you want to go further. And when you have a look in the environmental law 6938 of 1981, Article 3 defines pollution. And here the big deal. The legislator went further than any other of his time. And why? Because he defined pollution not only as conventional degradation of environmental media. We're talking about pollution of air, water, soil, and biota. But as any environmental degradation result from activities that directly and indirectly, and then I quote, harm the health, safety, and the well-being of the population, or create conditions adverse to socio-economic activities. This test was written when the legislator was thinking about oil refineries, about Cubatão, the São Paulo Industrial Valley, once called the Valley of Death. Definitely, he was not thinking about the recommendation algorithm. But this legislator of 1981 gave us today, the exact language to describe, for instance, what a TikTok algorithm contributed to the remaining elections of 2024. And if you have no idea what I'm talking about, we're talking about a presidential election that Romanian's constitutional court formally annulled because TikTok manipulation. The first such annulment in the history of the European Union. Or, for instance, we're talking about Facebook recommendation system contributed to in Myanmar, atrocities that the United Nations qualified as a genocide, significantly amplified by algorithmic systems. Or, for instance, what a YouTube algorithms did during 2019 Brazilian oil spill. I used to say a double pollution. Here we have the research is very interesting because the oil itself polluting the coast. But there is an additional carbon emissions of data centers that amplified hundreds of disinformation videos about the spill. Look, pollution producing pollution. And look at this, conditions adverse to social economic activities, written in 1981. It's just perfectly applicable today to algorithmic harm. And certification, I which now turn, is the instrument of that activation. But before I describe the framework, let me state a principle, a started point, because we cannot certify what we have not first been able to name. In my thesis, defended at the University of São Paulo and recently published a book by Revista dos Tribunais, I have mapped the environmental harms of AI in 2 dimensions. The first dimensions, the most visible, the physical environmental harms. I'm talking about ecological, the extraction of lithium, cobalt, palladium, the hairy earths for every GPU in every data center. The energy of carbon footprint, then we are talking about 500 tons of CO2 for training GPT-3 a long time ago, GPT-3 alone. Or the water footprint, we're talking about 700,000 liters of fresh drink water. And again, if you'd like to go further, because you don't have time to explain everything, here we have the QR code. You can check every information I'm talking about here. The electronic waste, the same. We have millions of tons of year with a hardware life cycle of 2 to 5 years about it. And don't forget, we have another problem, the induced over-exploitation. Because AI optimizing the extraction of shale gas, the depth of ocean mining, the intensity of agrochemical use in precision agriculture. But there is a second dimension, and here is very interesting because you are talking about pollution, a social algorithmic harms. That is the behavioral and direct harms that AI systems produce on the social fabric itself. Environment fraud committed by AI, I'm talking about. I don't know if everybody know about Dieselgate. Dieselgate was the first warning. AI can scale the same fraud. Look, and let me emphasize something. Dieselgate, we're talking about a first generation AI, to be simple. And imagine if the first generation AI, we're talking about 2009, because it was discovered in 2015. So if the first generation AI has already produced this scale of damage, imagine the care the generative AI will demand of us. Another example, digital pollution and democracy erosion, as a Romanian case illustrates, or damage to mental health, particularly among young people, documented in ongoing lawsuits against Meta and TikTok. And again, if you don't know what I'm talking about, you can Google, you can check here, and it's unbelievable how deep and serious it is. And there is another point, the transition from attention economy to what researchers have recently called in the intention economy in the late 2024. This transition to intention economy amplifies unsustainable consumption along every link of supply chain. Look, old harms, new ones, physical degradations, behavioral degradations, and guess what? All reached by the scope of Article 3, again, written in 1981. And there is another point, important point, the polluters. Again, the Environment Law of 1981, again in Article 3, Item 4, defines the polluter as any nature or legal person, public or private, responsible directly and indirectly for the degradation. Two adverbs, directly and indirectly. And what does it mean? He could not have anticipated that 45 years later, the same adverb would reach, guess what again? The big tech company, whose recommendation algorithm operating for a data center on another continent produce social environmental harm in our territory. But the test already reaches. This is what I call algorithmic polluter. Big tech as the source of pollution that is not accidental, but engineered, and Brazilian law can reach it. So here is the framework of certification that I propose. For X, it responds to specific categories of the map I have just outlined. The first X is physical infrastructure. I used to say where the harm is most visible, regulating energy, water, electronic waste from data centers, with full integration into our 2010 National Solid Waste Policy. The second X, I used to say, is upstream to hardware supply chain. Traceability of critical minerals, certification of origin, and alignment with international standards, particularly the OECD guidance on conflict minerals. And the third point, third X, focuses on the algorithm itself. Independent audits of recommendation systems, risks metrics for compulsive use patterns and behavior capture, and transparency of training data dimension. And finally, the fourth X, shared institutional governance, where certification operations reach financiers, data providers, and developers, indirect polluters of the map. So this framework rests on existing institution design of Brazilian environment governance, supported by Article 61, is the only one article that we have on our pending AI bill, and connects with international mutual recognition. So, in short, my argument it is, the Brazilian legal framework already gave us what we need. Not in the AI bill now pending in our Chamber of Deputies. This is a complement, not a foundation. Our foundation is in the environment law, the 1981 law. And one final point before I close. I have spoken of certification as obligation. But certification to produce real incentive must have two legs. And here again, Brazilian law, with the same foresight, provides the second leg. The protector-receiver principle established in Article 6, Item 2 of the 2010 Solid Waste Policy, and then developed in the 2021 National Policy for Payment for Environment Services. Under this principle, agents who protect the environment have the right to economic recognition. And what I'm talking about, tax benefits, better credit terms, and access to public funding. So certification is the bridge between the operator who adopts good practice and the state that rewards them. And let me summarize what Brazilian has without a single new law being necessary. First of all, you can see we have a concept of pollution, broad enough to name many new categories of harm, including the new one when you think about behavior like TikTok manipulation and other else. Second point, a conception of polluter from the same law, broad enough to reach every agent in the algorithmic chain. And the fourth point, a protector-receiver principle from 2010 and 2021 to reward the operator who certifies. So what is missing, and this is my point, is not legislation. For me, what is missing is the political will to activate what 1981, 2010, and 2021 have already given us. And a final image to close here. I have come to think of Brazilian and European environment law for AI as a complementary experiments. Europe builds the regulatory grammar. Brazil already has the conception foundation. And what I believe that between the two, the merges a regulatory geometry capable of serving all societies, and more than this, the planet we share. So my point is this: the new shamanists are already here, but the language to name them was written 45 years ago. And what we need now, for me, is the will to use it. This is my point. We have foundation. We have the necessity to certification, and we have in our environment law everything we need about the concept of pollution, polluters, and important principles of the environment law. And I invite you, if you want to go further, know more about it. This is my work, published this year, where I have the opportunity to develop the framework I have briefly outlined here. Thank you so much for your attention.
Thank you very much. And I will open the room for questions. I didn't do this after my talk because I used too much time, sorry. And does anyone would like to pose a question to Vanessa? So we may move to Costanza Maesa. She's from the University of Siena, and she's also I'm also her supervisor at the University of São Paulo in his postdoc studies on a project where she has the very prestigious Marie Curie scholarship, and she's developing studies on green AI, in particular a project called Eco AI, which intends to discuss the possibility and ways of regulating AI in terms of environmental sustainability, and certification is a means for that, and we have been discussing this issue. So I give you the floor, Costanza. Thank you very much.
Thank you very much, Giuliano. Thank you very much for having me. I did not send the slides, so I'll talk and then I'll send them to you. So yeah, my project is not about certification, but it's about finding solution to draft a EU legal framework for an ecological AI. Because as Vanessa was saying, AI system may have negative impacts on the environment, and so now I'm not going to talk about them. During all the AI system value chain, so from the extraction of raw materials to the negative impacts of data center to the problem of disposal of e-waste. So I think that the current legal framework at the EU level is inadequate, and so and it is causing damages also outside the EU, for example in Brazil or in the global south. And so that's why we are also talking of transnational AI colonialism, because it's a new form of colonialism. And so now, but now I am reflecting about certification of AI for environmental sustainability, also because in the legislation there are some inputs on it, especially in the Brazilian one, as Giuliano was saying. Is especially mentioned that there can be certification schemes for environmental sustainability, and we can find some other issues also in the EU regulatory framework. So about I'm going to talk about the EU and Brazilian legal framework briefly to understand what is already mentioned in the current regulatory framework, and then I'm going to talk about the issues that may arise. Giuliano already talked a lot about it, and Vanessa as well, so I'm going to skip on what they already said and try to point some new points. So at the EU level, the regulatory framework is fragmented as regards, let's call it green AI, but is so the sustainability impact, the environmental impact of AI system. And the main regulatory instruments are the EU AI Act, and then the different legislative acts that have been adopted to implement the European New Green Deal. Among them, there is the critical raw materials regulation, the waste shipment regulation, the due diligence directive, and the directive on energy efficiency, and the eco-design for sustainable products regulation. I'm not going to analyze them in depth. Georg already talked about them this morning about the EU AI Act, so I'm just focusing on the provision of this act that are relating to environmental sustainability of AI system. So in the EU AI Act, there is a focus on standardization requests rather than mandatory requirements. So there are no mandatory requirements, and there is the absence of a clear coercive mechanism. AI providers and deployers are encouraged to create codes of conduct. This morning we talked about code of conduct and voluntary mechanism on a voluntary basis. And the attention is mainly placed on energy consumption. and not on other issues that Vanessa also highlighted, so as water consumption and destruction of ecosystem, in many cases deforestation deriving from the extraction of raw materials, and so all the other negative impacts deriving from the use of AI system. So in the AI Act, we cannot find harmonized indicators to measure the ecological footprint of AI system as a whole. So considering all these negative impacts, as we will see with regard to the other instruments, that a common element, that there are no common standards to measure it. And I think that is a main problem even for certification purposes. And I would like to discuss with Vanessa how she thinks she could solve this issue. And then there is the regulation on the on raw materials, on critical raw materials, that has been adopted at the EU level. And there is a precise reference to certification scheme to guarantee the sustainability of raw materials. And it is stated also that the EU shall promote strategic partnership with other countries. So, for example, in Brazil, as we know, raw materials are extracted in third countries mostly and not in the EU. So we'll see why, in my opinion, that's a problem, that the only instrument are certification schemes. Then as regards data centers, that will be a case study for me today to discuss about it. At the EU level, they are regulated by the Energy Efficiency Directive at the moment, and now there are new regulations that will come, and by the Commission delegated regulation. Here we can read that data center operators have to collect, make publicly available, and report to an EU database information that are relevant for sustainability assessment. So there is already something. But again, there are no binding efficiency and renewable energy targets at the EU level. And there are not binding reduction targets specifically for data centers. So member states in the EU, we retain a broad margin of discretion in determining how they will contribute to the objective of reducing energy consumption, if we consider only energy consumption, because the problem is also that it's always considered only energy consumption. And there are other acts that can be taken into consideration. For example, the eco-design for sustainable product regulation, because it lays down minimum energy efficiency, resource efficiency requirement for servers and data storage product placed on the EU market. And so that's important because there is an emphasis on products and on the fact that they should be sustainable, and so it should be an important instrument for consumers. We talk also about an EU passport, so that you know whether the product is sustainable or not. But again, there are no common standard, and is not specifically addressed to all the other stages of the AI system value chain. And so it is doubting that it will be an instrument that at the moment, without other implementing regulation, will make a change. As regard the huge consume of water that she described before, there are no data center specific provisions at the EU level, and that's a problem because there are no way to control the consumption of water by data center, and it is unregulated at the EU level at the moment only by other laws, general laws. In Germany, Germany have implemented the directive more strictly, so there it goes beyond mere reporting. So this is an example of a member state that regulated it more strictly, but there are some others where they did not. So as I said before, there is no uniformity. Concerning data center, concerning the Brazil regulatory framework, there is the draft B that has been adopted on February this year, Redata, where there is mention to the use of renewable energy sources and water efficiency, but again, it should be defined in further regulations, and so at the moment, again, there are no common standards. And another relevant piece of legislation is the draft bill 3018-2024 on AI data centers. But again, there are some provision, again, obliging AI data center to adopt certain measures aimed at ensuring energy efficiency and environmental sustainability, but there are no sanctions, no specific sanction in case there are not, in case to failure to comply with them. And there are no clear guidelines on minimum efficiency mechanism or mechanism for auditing and monitoring. As Giuliano was saying before, the Brazilian context is different from the European, so at the European level there is more a central even government model. Here is more fragmented and local. But yeah, so there is not, and there are no common standards at the central level. At the same is to say for the draft bill on the AI that Giuliano discussed already before, as we are short of time, not going deep into it. And this is the same for the Brazilian environmental licensing system, because data center, for example, are not included as a special category of activity subject to licensing, so it is states and municipal authorities' competencies to classify data centers projects, and so that's why these projects are mainly proposed in states as El Dorado do Sul or in others, in the north, I don't remember the name, but also in the north of Brazil, where there is this TikTok project of a big AI data center, where the regulation are more favorable for companies, and so foreign companies from the US are building data centers there. So what's the problem for certification? First of all, considering what we just said, that there are no common standards and no environmental standard to measure the environmental impact of AI system during the all AI system value chain. So from raw material extraction, there is the problem. For example, there are many reports now about certification and the inadequacy of certification scheme to certify that there is no deforestation. For example, the Forest Stewardship Council certificate or other certification, unfortunately, they're not effective in certifying that there is no deforestation, and there are many reported studies about it. And there are different problems. The first one is the problem of greenwashing. Now at the EU level there is a specific directive on greenwashing, which is the following. I don't know if you know what is greenwashing. Is that why do companies want to certify? Because of external pressures, and so search for legitimacy, because consumers are willing, at least in Europe, I think in Brazil as well, it may be the case, to buy products that are more sustainable. But the problem is that sometimes these self-assessment certification schemes are based on poor standard, and the certification board is not really independent. As Giuliano was saying, independence and autonomy is important. And so in the end, they are not really sustainable, but they claim to be. And so this is greenwashing, and it is advertising to incentivize consumers to buy these products, but this is not really the case. So this is a problem of certification. If there is no mechanism in place to ensure that certification boards are really independent, and if Giuliano was saying, if there is not a state control or a centralized control at one point, and if it's only private certification, at least that's what happened in the sustainability certification, as I was saying before, with forests, but even with other products, that in many cases it was greenwashing and not real sustainable products. And then there is the problem of opacity and secrecy, and the problem of availability of data. For example, as regard data center that we were talking about, the US companies and the Chinese, which are the leading companies in the sector, for example, pushed the European Commission in 2024 to amend the legislation and to classify as confidential and commercially sensitive all the information on individual facilities footprint. So it's kept secret, and so the individual companies may say they do not want to disclose this information of its environmental footprint because of secrecy. There is there are some problems of compatibility with EU law in this case, because, for example, they may be not compliant with transparency rules and with the Paris Convention on public access to environmental information. There is the same problem in Brazil. Another problem in all the legislation is that the public participation and information is not ensured. And in Brazil, it is compulsory because of International Labour Organization Convention 169 on the right of indigenous people and local communities to be informed if, for example, in the case of data centers who is contributing to the degradation of their land is being built on their territory. And at the EU level, because of the Paris Convention, which is an international convention to which the EU adheres, that ensure that the public shall be informed, and they have also to participate in the decision-making process. So, for example, to approve a project of a data center, they shall be informed, and in many cases they are not informed. They just see the data center when it is under construction, and so there are of course problems, and this means opacity, and of course it's even more difficult to adopt certification schemes if we do not have data. That's what Vanessa was saying before. In a case, if we cannot name it, how can we do? And in many cases we cannot name it, and legally not name it, because they are protected by confidentiality rules. Yeah, that's we talk about. So if we can think of some possible solutions, if we want to adopt certification schemes, that I don't know which is the best solution or not. Georg was saying even if we have to propose it or not, and Giuliano was saying that maybe it's better to create a marker for it. If we want to create a marker for it, we should ensure that indigenous people in Brazil or local communities right in the EU are included among the standard and the right that should be respecting while conducting these certifications. Certification standards shall be adopted at a central level so that they are clear and they do not depend on municipalities. Then, of course, they can be adjusted depending on the on the peculiarity of the local, but there should be, it seems, some guidelines on it. Certification schemes should also require full transparency and maps of certified areas and details on the ownership of certified companies, because like this we can check whether they are the same person who certify are those who are certified, which is the case unfortunately sometimes. And to ensure that there is more independence, we could foresee the rotation of the independent experts who are part of the board and of auditors. So if they are not the same, there is less possible that they know the companies and they are not independent. And then an obligation to publish audit reports and indicate any non-compliance with the standards, which is not the case now. And as Giuliano was proposing, also applying and enforcing appropriate penalties. I think that if some measures are taken, we can think of considering certifications schemes as useful. If not, if it stands as it is now within the current legal framework, I don't know whether they can be a useful tool or not to ensure that AI systems are really sustainable during the whole value chain. Thank you very much for your attention, and sorry for not having the PowerPoint presentation, then I'll send it to you. Thank you.
Thank you very much, Constanza. So, I think we are comfortable with time. Let us open some time for questions. If you'd like to pose some questions to either to Constanza or to Vanessa, please feel free. No, I would like to make one. I have pointed out that it is really a challenge, the matter of legitimacy of the certification program, especially regarding the protection of public interests. And I see no other way of building it if not by integrated the role of the state with the private organizations that are involved in the certification. So in our proposal, the accreditation would be made by this, would be responsibility by the state in our proposal, and this is what is present in the Brazilian draft bill. And there is also provisions for empowering the state for revising or for supervising the development of the program. And of course there are the attributes of impartiality, independence, but this is not yet specified in the legislation. Probably this will be detailing for a decree making further specifications to the law. So I'd like to know better from both of you about the certification programs in the environmental field for environmental sustainability. You have been criticizing them for not for sometimes bringing greenwashing and not being that reliable. Could you point out some omissions that you think were the cause of such illegitimacy or for these programs?
In the report and the study that I read, the main problem was, independence. So in many cases, the certification board was not really independent. Then there was the lack of clear standards. So there were different standards because in case of sustainability certification, there is also a problem of cross-border jurisdiction. So the value saying concern different jurisdictions. And so, for example, in Africa or even in South America, in many jurisdictions, there was not really a control. Yeah, there were some crime in some cases as well, but even without the crime, the standards were really low and were not the same at the EU ones, but still it was certified as sustainable, and so it could be sold on the EU market. And so there were disparities, and for example, the Forest Stewardship Council label, in some cases there was deforestation, but they said there was not because there will be program of reforestation, but in reality then there were not. And so all these independent rappers testified that they were not working. So that's also one of the problems. Also, different jurisdiction, different standard, and then there is the problem that maybe the main company is not the company extracting raw materials, but is not even a subsidiary, but is somehow connected. But for example, in one case that analyzed, only the subsidiary should abide by the same standards, but not other companies that were not. And so in this case, they were taking wood from and deforesting, but legally they were not, and they were certified as sustainable. So, or not only from environmental side, but also from the social side. And the state did not have so much to do. Yeah, just in many cases, just approved, homologated what was already said by the certification board. And so, but I think your proposal is important. If there is more control from some state authorities and a real control, so maybe even without saying when they're going or not, and controlling the certification schemes, that will be important, because they saw that with databases was more or less the same. These companies were proposing projects in municipalities where there was no control, not in Sao Paulo, but in some others where they could do whatever they wanted and everything could be approved. So yeah, that's what
In my point of view, the AI revolution, it's close to AI industrial revolution. And what I mean, I believe in Brazil, we have experience to lead those questions. What I believe our mission we could treat very well is put inside the Environment Law 6981, the data centers licensing procedure, and try to make a procedure like we treat chimneys. So we're gonna create numbers to energy, to use renewable energies, and about the water, usable water, about the acoustic pollution. We have many impacts that we could bring into our license procedure and treat like a new fabric, you know, like a new industry. Data center, for me, is like a chimney, and what we have to do only create some conditions in the system that we have already had. And this is the reason I believe with the 6938, the environmental law, we have the concept of pollution, polluter, we have everything. And I believe we can treat very well these physical impacts considering the license procedure. And like I told about another dimensional AI impacts, when I talk about behavioral and harm social, I think those harms are more difficult to lead. But when you think about physical impact, I think it's not something new for Brazil, because we learn with Cubatão, we have some experience. What do we need? I believe we need the political will. We have the foundation, we have the law. We need to create conditions inside the license procedure. This is my point.
And I have a question. And what do you think about it? Do you think that under the current legal framework in Brazil, would it be possible to?
I think that the idea of discussing with the experience the environmental field is to actually to learn from this experience, from what actually did work and what didn't work. And one of the problems, as I see, is that there were many different environmental disasters in Brazil, and the companies which were responsible for that actually were certified. Yeah. So there are problems with the certification in Europe as well. So I believe one of the main problem is an effective supervision of the certification arrangement. The way we have proposed in the proposal by logarithm to the Senate, we took care of bringing powers to the states, the AI authority, or to regulatory agencies, and in this case also to the Ministry of Environment Protection, to supervise the certification program, not only the structure but also ongoing, by really receiving reports by the certifying entities and acting upon these reports, and also being able to suspend the certification if some problem appears. Not all of these powers were incorporated in the draft bill, but it's not. But actually, it will be possible to complement them in further regulation. It's not that it became the change that the Senate made regarding our proposal didn't make it incompatible with. Actually, on the contrary, they just made it a little bit more general, but the state is empowered. It's a matter of building it with more supervision powers by the state, because then it's another layer of responsibility, and I think this is very important because, as I have said, the approach is much more on the credence model than in the testing model.
Yeah, then maybe making it public would
Yeah.
also be
Yeah.
effective, because consumer will maybe
Yeah.
not trust
And also, yeah.
they're not trustworthy.
Yeah, and also it will, in our first proposal, it would include the listing of the companies in public websites that were certified, that could be assessed, and etc. So that we would have an environment to produce trust, because in the end, in credence approach, it's about trust, and all the trust ruins when there are disasters or incidents by certified companies. Okay, thank you all. Let us then close this panel, and we go for a coffee break, and then we can come back in 15 minutes. Then we'll have Holger Hermans is going to give a presentation, and then entice us for bring provocations for a little bit of a discussion. Okay. Not everybody came from our coffee break, but let us start our session, our last session, and we will have here a talk by Professor Holger Hermans, and then I will ask the leaders of the Brazilian and German team to come here for round table, which will be coordinated by Carlos Portugal Gouveia. I thought Holger would have to provoke, but our colleague here, Carlos Portugal Gouveia, came with several provocations already. So you are going to be provoked and not provoke. Okay.
Okay, I guess so now I try not to provoke. This means I have to change my slides. No. Okay. Now here's the first non-provocative statement. I'm a computing person, which means I have solutions. Okay. I understand that legal scholars, they are good in identifying problems and having strategies to discuss them. No, this was the non-provocative part. Yeah, let me tell you first one slide who I am actually. I'm a professor of computer science at Saarland University. I also run a center where computer science people meet. It's called Schloss Dachstuhl, and I'm mainly the research that I'm currently doing is in a center which is called the Center for Perspicuous Computing. This is a place where in the order of 50 PhD students are working on something which we call perspicuous software systems. And I will tell you a bit what this is because it motivates most of my research. So what am I actually working on when I'm not talking to legal people? I work on low Earth orbit satellites, like 6-liter things that are in orbit. I work on storm surge barriers. I make sure that storm surge barriers actually do the work that they're supposed to do, namely closing when the storm comes and not closing if there is no storm. And yeah, we have been doing a few more things in space. We have projects on mega constellations nowadays with the European Space Agency, where it's about how to route data in space, basically. And this is what I actually do in my normal time when I'm not in Sao Paulo or elsewhere. But this, what I was telling you about, namely the Center for Perspicuous Computing, this has a motivation that is now roughly 8 years old, or maybe 9 years at that time, and this was actually motivated by the diesel emission scandal that was mentioned. We saw that there is more and more opportunities for software-driven innovations. So there's actually an explosion of opportunities for software-driven innovations, but this comes with an implosion of our own opportunities and capabilities to understand and control these innovations, right? So this was the observation that we had back then when the AI wave was just starting, but I think it has become more striking these days. And in this context, then I started talking to people in law. There was also this other beautiful project mentioned by Georg Borges on explainable intelligent systems, where we collaborated, where it was about somehow being able to explain what's actually going on in these systems. And as part of that, then the AI Act came along and so forth, so I looked more into that. So we wrote a paper called AI Act for the Working Programmer, where we tried to explain what is actually in this AI Act. If you are into software, what do you have to know about the AI Act? And well, this somehow gives me some motivation to be here and to talk to you and to listen to you. And today I want to talk about 3 things. So the first thing is I want to talk about human oversight of AI systems. I want to talk about traceability of AI systems. And I want to talk about elephants. And as you know probably, because AI is basically everywhere, our way of reasoning starts to approximate what AI does. I don't know whether you're aware of that, but in order to imitate that, I cannot count to 3. right? So I have actually a fourth item, like a good AI, they can also not count. If they count, then they don't use AI, they use standard counting technology that was in computing before, right? So anyway, so the last topic that I'm going to talk about is risk and chances. And for the sake of it, I start with that. I start with risk and chances, and then so I meander through this stuff with you. So what do I want to say about risk and chances? So the first thing is, I mean, wouldn't it be great if there were AI that is accurate in 99% of the cases? That I think that would be fantastic, wouldn't it? I mean, nowadays this is not really the case, but it would be great, right? Good. Now, imagine the AI would be there, and it would be 99% correct in the first answer, and then it would be 99% correct in the second answer. So if you then do a bit of math, you see this is the probability that it's still correct after 100 steps, after 200 steps, and so forth and so forth. And what does this mean? What does this mean? It basically says that after roughly 70 steps, it's better to flip a coin because you're below 50%. Okay? So even if you have a 99% reliable AI and you pose it 70 questions, right, then probabilistically, right, this is 0.99 to the power of 70, and this is below 0.5. Okay? So now, okay, this is a very much a back of the envelope calculation, of course. But at the same time, I mean, think of this, right? I mean, nowadays there is not one AI, there are so many AIs, right? The AI is basically everywhere. And it's probably good. I mean, like 99 or maybe nowadays maybe 90% correct, right? But there are so many of them that it's getting a bit, let's say, worrisome with very simple calculations. Yes? That was my first, let's say, anecdote that I wanted to make. Now I get a bit more technical, and I talk about human oversight. Human oversight is a topic of the AI Act. It's Article 14 that is on human oversight. And what I'm doing here is I'm kind of tearing apart the Article 14, and I give you a very short summary of what more or less we think human oversight is, and then I have a bit of certifiability discussion regarding human oversight in relation to this Article 14. So we think in order to be able to do human oversight, well, what is this? This is the supervision of a system by at least one natural person, typically with the authority to influence its operation or effects, right? It has the authority to influence its operation or effects. And in the AI Act for high-risk AI system, this is foreseen. So if you have high-risk AI, like you have an AI that corrects exams in schools or so, right? Then there must be a human overseer, someone who looks over the shoulder of the AI. Okay. Now, what does this person need? It needs a few things in order to be effective. It needs to have what we call epistemic access, namely having sufficient knowledge of the decision situation. So what is actually to be decided, right? That's more or less the first point. Then second, it needs self-control. So it can decide for any path of action and follow through. So it is able actually to exercise control, right? Third is causal power. It has the power to establish a sufficient causal connection, right? So it understands if it does this, then this happens. Like if I push a stop button, the system will stop, for instance, right? Or if I nudge the system slightly, then grades will become better for the girls, or something like that, right? And the fourth one is it needs fitting intentions, right? The person that has the authority should also be willing to do the task to the extent that it actually is effective and it helps the system, right? So it has fitting intention and for the role, right? So, and if you now map this to this Article 14 in the AI Act, you actually find that right. So this is roughly the AI Act. I don't want to spend a lot of time on this, but it has like a few concepts that are on very, very different levels. For instance, there is to remain aware of the automation bias is one of the things, or to push a stop button, right? So these are the concepts that are there. But if you try to map this on what we have, you essentially find that with the first three, you can already cover this article. And what is not mentioned, but what is implicitly there is the fitting intention, right? If you want oversight to be effective, then the person who does the oversight should not only have the authority, but also the willingness, right, to do it. Okay, so this is a very rough analysis in short time, because we are tired, it's the end of the day, of what we understand, the European AI Act understands of the term human oversight. Then you can look a bit deeper and you can try to analyze what are the facilitators and inhibitors of human oversight. And then you can find that this falls into three things, namely things that roughly are under the control of the computing people, namely the technical design. Then there are factors that are related to the person who does the human oversight. And then there are environmental factors like time pressure, job design, and so forth, right? And you can do more there. I mean, here's a snapshot of our paper that was an ACM fact some 2 years ago. I think we did it. So you can distill this a bit more. But for us, it's probably interesting. How about certification? So what if we now want to certify the human overseer, right? So now, okay, what about the certifiability? So there are some obvious conditions for certifiability that I'm happy to discuss with you, but I mean, I have four, namely, obviously there should be a clearly identifiable object of certification. There should be a standard that the object should fulfill. There should be sufficient evidence that the object meets the standard in order to be then certifiable, right? And then the process that involves all this, especially of point 3, should be practically viable, right? Now, okay, as you know, we are in the situation nowadays that there is a lack of clear standards. We discussed this already. Okay, well, why is this actually the case? And I will come back to that towards the end of my talk when I talk about elephants. Basically because they are open normative and empirical questions regarding especially human oversight, right? I mean, what is good oversight, how to measure that, and so forth, right? So this is not so obvious how to do that. But even if it were there, right, then, well, we would still need to formulate this in a standard, right? And then, okay, assuming that would be done, or let's say, how does this actually relate to the sufficient evidence? I mean, I'm now talking only about human oversight, right? It is not obvious how to measure this, right? You need cognitive psychologists, basically, that tell us how to measure the person's effectiveness and so forth and so forth. So it's not easy, and then it's of course context sensitive, right? It depends on what the task is. So to have standards that are apt for the situation. This was actually mentioned. Maybe it was in Renata's talk, right? The context sensitive was actually mentioned, and also the difficulty in measurement. So I'm actually just have different colors for similar things that we have actually discussed to some extent, right? Context sensitivity is an issue, and then of course there are these large numbers of very individual cases. The systems are changing, right? And even with the human oversight taking its role, the system is changing. So you may think of recertification and so forth and so forth. So that is not all very easy, but at least we have an understanding where the problems lie if you really want to do this, right? So this is certification, okay. Now, I want to leave it like that, actually. I somehow am in the mood to rush. I could now go back to the facilitators and inhibitors and discuss a bit more where I see the problems, but I want to go to something which is more funny and also more technical. This is now really computer science, right? What I'm doing here, I'm talking about traceability of AI decisions. Okay, now what is that? This is about tamper-proof, which means, I mean, non-forgeable traces of machine-learned and automated high-risk decision. This comes with a bit of overhead, so it only makes sense for high-risk decisions. And what I'm now presenting is a solution. Okay. Okay. Now, what is this about? This is about something that we call decision bill of materials, and I likely have to explain you. Not the word decision, but I have to explain you bill of materials. You may not have heard about this, but it is a concept that is it has been there for technical systems, bill of materials, like what goes into the system, right? If you have a coffee machine, what are the components that are in the coffee machine? What is there? Which screws are there? And so forth and so forth. This is bill of materials, right? And before I tell you what the decision bill of material is, I will tell you what is the origin, namely software bill of materials. Now this is, nowadays, it's a structured list of everything that goes into a software product, okay? So you have a software product and you want to sell it to a federal agency in the United States, you need a software bill of materials, okay? Now what does it contain? It contains what are the components that went in there? What are the libraries? With what library has it been compiled? What dependencies does it have to other packages and so forth, right? So relationships between the components is there. And this, then, we have extended this quite a bit, but the idea is that if you have this software bill of materials and you have all the dependencies there, and then one of the dependencies somewhere down gets a vulnerability, a security vulnerability, you can trace it in the software bill of materials and you can see, wow, my software is affected. Okay, I now take 3 weeks to fix it, or I take it out, right? So that's the idea. So it gives you, in a sense, transparency so that you know what's running, but in particular, it gives you fast reaction in case there is some vulnerability out there, okay? So that's what it's actually made for. And yeah, I mentioned that on the side. These SBOMs are required nowadays when you sell software to US federal agencies. And then there is the European Cyber Resilience Act that it will enforce SBOMs across digital products, basically, right? So when you have a digital product, you have to basically say, how did you get to the software? Okay, what went in there? And you have to deliver that. You have to be able actually to show it. That's the idea. Okay, so that's the background. Now we are doing this for AI. We're doing SBOMs for AI. This was a request by the G7 cybersecurity working group to have an SBOM of AI. We were not aware that they were working on that kind of white paper where they were asking for it. We just did it, but it fits very well to this thing. So what is a DBOM? So right, so here you see a standard bill of material, right? So what are the screws? What goes in there, right? But essentially now we are doing this for software, and especially for the software which is actually an AI system, okay? So it basically has bill of materials for machine learning, essentially, right? We do this for machine learning. We could do it for symbolic AI, of course, as well, right? So it has these bill of materials for training and for inference. And it has, in addition, this tamper resistance, which is not there for SBOMs, but it is nice to have. It is essentially making cryptographically ensured that no one can tamper with that, because everything is signed and so forth, right? So that's the idea. Okay, now, okay, here's a picture, right? So here you have the training, and there you have the inference, right? So there is a provider and a deployer. That is European AI Act terminology, but I think it's quite intuitive. You have a provider of an AI system, and then you have a deployer of an AI system, and then there is a user somewhere down there that uses it, right? For instance, the user uploads some picture and gets a decision, okay? Think of skin cancer, right? User uploads a picture and then gets the decision, no cancer, okay. Now, the interface that is provided by the system is the AI, and in the center of the AI is the model, right? The trained model. Okay. Now, we have all these components, okay, and essentially what the DBOM for training and the DBOM for the inference will actually do, they will essentially meticulously document everything that has happened. It is enforced basically by the system that if you use a certain Python script and so forth, this is all just put into the documentation, right? Okay, and then, so this is essentially every step is cryptographically signed by what is called machine attestation. I will explain you machine attestation. Okay, so this is an automated process that makes sure that if you do this well, you are sure that everything runs precisely on the machine that you did it with the libraries that you were asking for, and so forth and so forth. But sometimes there are steps that are by humans. Some human says, this is a good data set, right? This is a great data set for skin cancer, and then the human has to sign for it, right? Okay, so it may also be by humans. And so you have, of course, different roles here. You have the provider humans, you have the deployer humans, and you have the user. And the user doesn't have to sign, but if the user wants to, let's say, if the user says, I had cancer right? I mean, so there is a reason why also the user would sign with his name, right? You can say confidentiality, we don't want that, but for the others, I mean, confidentiality is not our point here, it is traceability, right? It's accountability also, right? If you want to be able to reconstruct who did what and what happened, this is the way to do it. I'm not implying that if you have all the information, you will be able to reconstruct the root cause, but without this, you will not be able to have the root cause analysis, right? So that's the thing. Okay. Then you may also have third parties. For instance, you have a pre-trained model or something, right? Or you have some software provider. Also there, then someone has to sign for it, right? Has to say, okay, we, company X, this is from us, and it satisfies the constraints that were in the contract, basically, right? So that's the idea. Okay, now I have to tell you a bit about machine attestation. Now, what is this? Machine attestation is actually something that you don't have usually when you just have a standard CPU. You need specialized hardware for that. That is slightly more expensive, right? And there are some from Intel, from AMD, and from ARM. And they give you what is called trusted execution environments. I will basically have another slide where I explain you what trusted execution environments are, right? And the nice part is that since 2 years roughly, this is also available for GPUs. So NVIDIA has it now for GPUs. So you can have machine attested training in GPUs nowadays with a Hopper 100 or after. And then, like you have to trust the signatures of the persons that go into that have something that goes into the system, you also have to trust the hardware provider, right? I mean, there is a trust anchor now, which is the hardware provider, and if you don't trust Intel, or you don't trust NVIDIA, or you don't trust Huawei, then this will not work for you, right? So, right? I mean, they could make a mess in the attestation, right? But okay, that's if you trust Intel, which you may want or you may not want, same for NVIDIA, then you can create a trust chain that links it all the way through, right? Okay. Now, so these specialized hardware, this gives us so-called trusted execution environment. So you have the standard operating system and all that here, right? But then you have strictly protected hardware resources where everything is controlled. It is slightly slower. We have measurements now on GPUs. It's a factor of 2 slower, which is not bad. It's actually not bad, right? But it also costs twice the power, right? Which for environmental reasons and so forth, it's more a factor of 2 and so forth, right? But well, that's how it is. So these trusted execution environments, they ensure that sensitive data and code are protected in terms of confidentiality and integrity. They are isolated from the processor and host system that they are part of. And they only execute specific applications that have been attested for use. Okay, so this is what it comes with. And in principle, this gives you confidentiality. But we are doing it for precisely the opposite. We are doing it for tracing precisely who did what. This is not about privacy here. It's about openness, actually, to make sure that we know who did what, right? Okay, now, so we do this for tamper-resistant documentation of training and inference, okay? And we have it running, actually. We have the GPU, we have the Intel TDX. We are about to release a web server that is running in a trusted environment so that you can actually play with it yourself. And you can download our stuff, and you can check whether the signatures are intact, and so forth and so forth. This is what we basically have, I would say. Okay, now, we have an application, and I could now have skin cancer here, which I think is a very nice topic, because you can do a lot of things. It may not be discrimination, if you ask Georg, but I think it's an interesting problem. But skin cancer is a problem because there is a privacy concern of the people who have the skin, right? Now, instead, we do mushroom classification. Mushrooms have no privacy, but it is the same problem. If you classify a mushroom as edible, but it's poisonous, then it may kill, right? So it is let's say the silly and playful version of the more serious case, right? Okay, and then we put in all kinds of analysis on top so that you can actually, if you have this D-bomb, you can analyze the D-bomb and you can actually say, okay, what are the concepts that are used for this mushroom to be classified as such and such, right? Which is standard computing technology where Hanwei, for instance, was telling you about yesterday, right? Okay, good. So yeah, that was traceability. So yeah, we are pretty proud of this. And we think that tamper-resistant traceability is essential to enable court-proof human oversight of high-risk AI system, where the human includes the judge, right? If the judge wants to oversee a high-risk AI system because something went wrong, then it's better that this is all traced and that it's tamper-resistant. And also we think that for AI certification, it is a good idea to have that, basically, right? It's a better system if it is traceable in this way. Good, so I have done already 3 of my 3 things. The last one that I want to do is elephants. I want to talk about elephants, and this is I think you know this. This is a non-elephant, right? Sorry, it's a non-hat, right? It's a non-hat. I guess you know that. If you don't know it, then you read this beautiful piece, Le Petit Prince. Good. Now, I am talking about something that is one of the heroes, let's say, of computer networks is Andy Tannenbaum. Andy Tannenbaum, and he came up with the so-called apocalypse of the 2 elephants. Okay, you have to now to imagine these are 2 elephants, and they are kind of colliding with each other, right? In this way. And this is a picture literally from his book, 2nd edition of Computer Networks, 1989, and there he explains the apocalypse of the 2 elephants. Now, what is in this thing in the middle? In the thing in the middle, there is the standard. Okay, so it's about standardization actually. So he actually explains why the internet is such a mess. So he explains that at that time there was the so-called ISO-OSI model, and that was beautiful, but what came out was a mess, and this is because the standardization didn't work in this way. Okay, so okay, what are the two elephants? One elephant is research, and the other is $1 billion of investment. Okay, okay. And now I'm reading with you the page of Andy Tannenbaum's book, and it says, okay, this figure shows the amount of activities surrounding a new subject. When the subject is first discovered, there's a burst of research activity in the form of discussions, papers, and meetings. After a while, this activity subsides. Corporations discover the subject, and the $1 billion wave of investment hits. It is essential that the standards be written in between the 2 elephants. It is essential that the standards be written in the 2. Okay, now, there may be 3 things. If they are written too early, before the research results are well established, the subject may still be poorly understood. The result is a bad standard. If they're written too late, so many companies may have already made major investments in direct ways of doing things that the standards are effectively ignored. Okay? If the interval between the 2 elephants is very short, because everyone is in a hurry to get started, the people developing the standard may get crushed. Okay? Now, if we look at the situation that we have now with AI, I think all 3 are true. It is too early, it is too late, and it is the interval in between is too short, right? Okay. You see the point, right? I mean, the research was on AI, but it was not on the let's say terrible effects that it may have, right? There was no research. The research should ramp up now, foundational rights and so forth, but it's very slow in starting. At the same time, there have been super many investments. I mean, billions and billions and billions and so forth, right? Okay, good. Yeah, this is what I wanted to talk about. I talked about these things, and I say thank you. Good question. Good question. Yeah. Yeah. I don't know. I mean, the risk that the standards will get crushed and the people will be frustrated is very high. Yeah. Now, I mean, there is this unique situation that it's kind of enforced implicitly by law, which is here was not the case, right? I mean, in the ISO-OSI model, nothing was enforced. It was just a suggestion.
Okay, thank you very much. We will have now a section with short presentations by the German team, the researchers by the German team, and then we make our final section of debates in a round table. Okay, so let us start with Afolabi, maybe? Okay.
Wonderful. All right. Good afternoon, everyone. My name is Afolabi Adekemi. I happen to be one of the members of Professor Borges' team, and I would like to discuss the ongoing work in St. Senelec. In our part of our conversations today, you must have heard about this standardization work that is ongoing with respect to the implementation of the AI Act and the importance of the harmonized standards in that particular implementation process. And so part of my research, since I joined this particular CARAT project from its very inception, is been to follow the development that is ongoing in that particular body that has been given the mandate to develop the harmonized standards that are quite critical for the implementation of the AI Act. So with that very brief background, I should also mention that, of course, being a member of Professor Borges' team is the reason why I am here, and very, very privileged and honored to have that relationship now with Professor Mariao. And it's been a wonderful journey, I must say, and thank you very much for the wonderful host that we have experienced in the course of these days. So I would not like to take too much of our time. I will just quickly run through my presentation in the next 7 to 10 minutes. Today we have talked extensively about what conformity assessment is and the role of the harmonized standards in this conversation. So I would just like to lean on that and quickly go into what is most important that I would like to highlight before the House. And that is basically the importance of the harmonized standards in this process. And that actually has to do with the result that emanates from the conformity assessment process, on which the harmonized standards are very, very, very critical to lean on. And it's important to point out that the results of the harmonized, the conformity assessment procedure, which is actually undertaken through the use of these harmonized standards by companies that are operating AI systems, that deploy AI systems in the market. Now, what it does essentially is to create this presumption of conformity. And that presumption of conformity is the tool essentially to market access for these AI systems, for the majority of AI systems that are regulated in the AI Act, particularly the IRIX AI systems, which is the main subject of regulation in this particular act of the European Union. So with that understanding, we come to the duty, the work of St. Senelec itself, which is to develop those harmonized standards that are critical for, for example, the conformity assessment procedure. So just quickly to introduce what the St. Senelec body really is, because we have been talking about this body for the most part of today. So CEN basically starts for the European Committee on Standardization, while Senelec is the European Committee on Electrotechnical Standardization, and they have this mandate to provide harmonized standards in 10 key areas of the AI Act. And one of those areas is actually regarding conformity assessment. And with respect to conformity assessment in particular, we have Working Group 2 that is undertaking the discussions on the development of these harmonized standards. And the areas that this conversation basically covers is the next thing I would like to highlight, part of which has also been discussed in the presentation of Professor Burgess today, is that there is a conformity assessment framework that is currently on the works, and this is particularly tagged the PREN 18285. And part of what it covers are those IRIX areas that has been identified in the AI Act, which includes the importance of having an assessment of the risk management that is in place for the IRIX AI systems that are in the market, data governance issues, technical documentation, transparency, and so on and so forth, as listed on this slide. Now to the main area of my discussion, which is also something that we are having on the agenda at this moment regarding mapping the challenges that has to do with the implementation of these harmonized standards. The ongoing work in St. Senelec has reviewed some of those critical issues that have been discussed both by lawyers and also technical experts that are working in this particular field. And what I've uncovered in my research are actually these three main issues highlighted on these slides. And to start with the number one on this slide is the issue regarding transforming legal requirements into technical standard. And I think that this is actually the number one issue that has plagued the progress of developing the standards, because when we are talking about the issues surrounding fairness, surrounding transparency, surrounding non-discrimination, how to translate this legal requirement, so to say, that has been provided in the AI Act, particularly requirements for IRIX AI systems, how to translate them into technical standards is quite a big challenge. And lawyers, computer scientists, philosophers, and all those that are involved in the ongoing discussion in St. Senelec find it quite difficult to establish a common ground on what should be the standards for conformity. And the next one is the issue regarding the horizontal nature of the AI Act itself, as opposed to what we have in traditional product safety regulation in the EU in the past that is typically specific to a product. But with respect to the AI Act, it applies to all systems that has been categorized as high risk, and they have to comply with what we have in Chapter 2, Section 3 of the AI Act itself. So this vertical application, horizontal application, is also a big challenge. And it's something that requires a lot of consideration from the experts in finding the right compromise. And the discussion that is really out there in the public, following the literature's comments from experts that are involved in this process, shows that there is no much progress at the moment on finding the equilibrium that is necessary for application to having a standard that applies across board. So this is one major challenge. And of course, having philosophy, psychology, even in the health sector, in the medical sector, having all of them to come to a conclusion has really, really slowed down the progress in developing these harmonized standards. So there's this slow progression to consensus, so to say. So these are some of the critical challenges that I would like to pontificate before the House, and I hope could stimulate further discussions now based on what has been highlighted in this 10 minutes, I will say now, 10 minutes, 4 seconds. So on that note, I would like to just wrap it up and say that it's still work in progress. Thank you very, very much. No questions?
Then we can make follow. So, and Jonas, you may wait here. Then we make a round of questions for all of you. And Julian now. Okay.
So, thank you really much for the opportunity to speak here again. Some people of you will know these slides from yesterday, but still be excited. I changed them a bit because I have this really short period of time of 7 minutes, and yesterday I had the feeling that some things still were a bit unclear, so I changed some details, also referring to the discussion between Professor Borges and Professor Maragnaro at the end of my presentation. I'm Julian, so I'm the German Giuliano, you could say, and I'm also part of the team from Professor Borges, and I'm the oldest one in the team because I joined the team in 2022, and I want to present you again the classification of high-risk AI systems under the AI Act. Why is it important? Because the classification under Article 6 of the AI Act is the door opener for all the rules that are established in the Chapter 3, so Article 6 to 49, and we have two concepts of for the classification of high-risk AI systems. It's a list-based approach, so at first we have the list in Annex 1 and the list in Annex 3. Annex 1 is a product-orientated classification as an AI system. So if an AI system is a safety component of a regulated product, yesterday, for example, we had the discussion about medical products, for example, and the second one is Article 6, paragraph 2 and 3 in conjunction with Annex 3. So here we are talking about high risk areas. And here we have two conditions: use of the output of the AI system in a high risk area, Annex 3, and the more, I would say, the more difficult condition, a specific risks posed by the system in Article C, paragraph 3. And the big question now is, what are these specific risks posed by the system in Article 6, paragraph 3? So how can we really detail them? How can we get a sense for these specific risks? And yesterday we got a presentation that showed us, hey, in Brazil there is AI in use. Judges use them. We heard of Minuta AI, if I'm correct. Yesterday I thought at first it was Minuta AI, but it's written Minuta AI. And they have like more than 800,000 abos, for example, and it's now a rich guy. In Germany, we don't have exactly the same thing. Our AIs that are at the moment in use are more basic. We have, for example, Marco. We have, for example, Jano. We have, for example, Struki. But we decided to do a bit of research about Frauke. It's a Frankfurt Judgment Configurator Electronic, and it's applicable or at the moment used at Frankfurt for air passengers cases, like so claims for air passengers' rights. And don't think too much of this AI. It's only more of a construction kit. It's a toolbox, and used for information extraction and comparison with information from the database, but the judge is always in control. It's more like a click-through game, you could say, for the judge than, for example, Minuta AI that was presented yesterday. And so now we think, is this a high-risk AI system? Then we look in Annex 3, is in high risk area, is in high risk sector, and is now this rule applicable to Frauke? And we have a mediating approach and say, yeah, everything that is related to the decision making. It doesn't have to be the subsumption itself, also only, for example, the determination of facts or the legal position. That is enough. And so in our example, Frauke, yeah, this is part of the high risk sector in Annex 3. But now, the main point of my presentation, do we also have this high risk? And there we have two components that are important. We have one, the criticality of the process, and the second one, the impact of the AI system on the process. Let's talk about the criticality of the process, because the greater the potential harm to data subjects caused by the process is, the higher the risk. That is the first point we have to point out. And concerning the impact of the AI system on the process, the more human activity is replaced by the AI system, the higher the risk. So the less control by the judge, the higher the risks of the AI system. And now we have these two criteria, criticality and impact. And now we, also not we, but Professor Borges and Till Elborg von Sync GmbH, they evaluated the Saarbrücken taxonomy for high-risk AI systems. So we tried to make a taxonomy out of this form of subsumption, and for criticality we did 3 classes: high, low, medium, and impact 2 classes. Is it a high impact or a low impact of the AI system, or do we have perhaps still a human control? And for Frauke, it's a medium criticality. For example, a flight to a good friend of mine to Milano at the beginning of last year. It costed us like 25 euros, for example, and that would, for example, also be a low criticality. But if we go in average with around 300 euros, we are at a medium criticality. Impact is low. The charge is always in control, so we have no high risk AI system. Thank you very much for your attention, and thank you.
Please come Hawaii and Jonas. So then first Hawaii and then Jonas.
Yeah, okay. Hello, my name is Han Wei. So first, maybe I introduce a little bit about our team. I'm working in the chair of Holger Herman, and our team is like the CS teams in Saarland University. And we have actually 3 people. Our professor, Holger Herman, is actually experts in the verification. And then we have the Saha's team, and she also a philosopher, and she's invested about the ethic of the AI things. And then it's me, and I'm manning. My background is focused on the AI, especially the trustworthy AI from the adversary robustness and the interpretability topic. So these topics, actually, we're trying to talk about our technical part, about what we do for evaluating the robustness and reliability for this project. So nowadays, as we are talking the whole days, AI is actually using quite a lot. But unfortunately, we found such kind of the AI model are very easily to attack. So we can generate such kind of the small perturbations, and we add to the images. For the humans, there are 2 images actually exactly the same, but for the network, they will make completely different decisions. And imagine this case if we put such kind of images in some traffic sign, then self-driving cars was just recognize it completely different, then we will have troubles. There could be some very serious accident happens. So then we have to raise what about the what we can certificate the reliability, safety, or some robustness problems about the AI models. So today we mainly focus on the robustness and the reliability, and then we first talk about what is the robustness. So for the robustness, we're normally referring the 2 parts. One part is we think that is some accidental failures. So that is maybe when we design the model, we are not thinking about that would be happened. So that could be some corner case. Some users will have some behavior we are not expected. So it could be some very random behavior, but that make the systems working completely failure. And another situation is we call it adversary failures. So we have some ones is actually have ill intention and trying to attack whole systems. So in that case, the attackers trying to exploit the weakness of the systems to make some errors. And for these two type of things, we actually all considering about robustness. And for the first type, because it's normally accidental, so we only can collect all these case by putting the systems in the uses and then collecting all the counter examples. So for our researcher part, we focus on the second part. We're trying to attack the systems in all different scenario, and then seeing what is actually problem could happens in these models. And then we're thinking if the model are more robust to the attackers, which means the models are normally more robustness. So our approach is we can define a set of attacking methods to the systems, and then to compare how robust the AI systems facing such kind of attackers. So in our definition, if a model are more robust, it means it's harder to attack. The harder to attack means it needs more computation resource, or it needs to have more modifications to make the make the attack a success, or it would be some more difficult design about the mechanism to make such kind of attack possible. So here we start with the very simple class, how we define the adversary attack from the beginning. So normally, everyone would know that it's a very common task in the AI model. We give it images and then ask what exists in these images. So we call it image classification. If we give it a cat, then we expect it classified correctly. Then if you want to attack such kind of systems, then we need to consider two things to make it success. One is we want the systems cannot recognize the cat successfully. And the second, we want the modification could be as imperceptible as possible, because this is the only way make it a valid attack to the systems. So, and then mathematically, we can put these two terms into some some mathematic functions. For the misclassification, we could see the systems will have the high possibility to recognize these cat images as a dog, or they cannot recognize it as a cat at all. And then for the modification, we can use the LP normalization to measure how much we modify it. And once we have these two things, we can use an optimization algorithm to solve this problem and to make the attack possible. So following the same philosophy, we come to the more complicated case in the self-driving cars. So we design different data format. So the first is like the LiDAR-based things. So we are considering two attacks. One is we just modify the LiDAR data, so it would be some cross points. We just modify its position a little bit and to see if it's possible to attack the system. The second is we can assume we can produce or 3D print object in the real world, and we can see if we can make such kind of object so that to make the models not working at all. And also, we can also attacking more modern mathematics in the AI in the AI 3D reconstructions, and we just take several images from the same things, and we trying to reconstruct the themes with the images. And in this case, we found we can attack the systems by just add a slight little bit perturbations in the images, and then they will reconstruct the chairs or the scenes in the way looks like the correct for humans, but actually cannot be recognized by any AI models. And also we can attack it by reconstruct a thing that everything is correct, but for some specific angles that would have some wrong information. So for instance, we construct a European street in these images, and then for most of case, we can see the traffic sign have the correct information. It's a stop signs. But then for the attacking views, we can replace by some other traffic sign. So all these kind of attacks was defined a set of the critical situations could happen in the AI systems. And then we use all these attacks as some stress testing to evaluate how robustness AI model is. So this is what we are trying to do for the robustness part. And then we're talking about the reliability. So the reliability is actually not exactly the same as robustness. The robustness is talking about when you have some unexpected inputs, if you can still perform correctly. But reliability is more like how stable your performance. It's like if you correct in this case, are you always correct? Or even if you make mistake in some cases, you always make some mistakes, we still count it's like some reliability, because the performance of the AI models, it would be expected. We will, so people can expect it when the AI will correct and when they will make some mistakes. This is what we define as reliability. However, in AI models, such kind of things is quite difficult because it's, as mentioned previously, in AI models, we have some certain randomness was including there, and the AI model is end-to-end. We cannot understand what the component was inside and so we cannot easily analyze the influence between the elements. So then, so what we think is possible is we cannot really improve the reliability objectively. What we can do is we convince people it's actually reliable. So this is also what our professor was mentioned today. We can use some the human oversight. If when people they oversight the decision of the AI model, they can monitoring what is actually happening, and then they have some ways to intervene the decision of the AI model. They might feel the model is more reliable than without any means to interfere it or understand what is happening inside. So to do that, we need some interpretability to provide some explanation so that we can open the black box of the AI. And then we're trying to also, based on such kind of explanation, we can have some intervene. So it's like it's also like the Renata was mentioned today. We should not drop the symbolic things. So what we're trying to introduce in the model is some concept representation. So instead of only have the input and the final decision, we will have some intermediate concept things to represent how the model was recognize things. For instance, for when we have the bird things, we first ask what the model recognize some concept relates to it. It's like the wings, the tails, or the peaks. And then based on this kind of symbolic concepts, we make the final decision. What we're trying to do here is we're trying to improve this and make this symbolic representation more reliable, because currently we found all these concepts, they actually cannot find corresponding regions in their inputs. So our research is trying to make it possible. We're trying to modify the mechanism, how we're training the neural network to make the concept align with the region of people could understand about this concept, so that the symbolic align with the human understanding, so the representation will be more faithful. And then by doing this way, we found then when we replace the human knowledge in this sense, they will actually improving the prediction. And previously, that is also ridiculous. When we replace the concept with the human knowledge, the accuracy is dropped. So that means something is not correct in the process. So basically, for the reliability, what we do is we're trying to propose some mechanism to help us to have better better human oversight, so that would provide us some interpretability. We will understand what the evidence actually the model was used to make to support the prediction, and then we also allowed human to modify it. And in this way, the user of the AI model, we will feel the model are more reliable, because if not perform as expected, at least we have the method to correct it. Okay. Okay, the summary is like we talk about what our technical, the development in the robustness and reliability, and we hope along this project we can test our model and trust it and govern it. Thank you.
Okay, today I'd like to talk to you about deepfakes and discuss whether deepfakes represent a use case for the certification of AI systems. I've been working at Professor Borges' chair for 3 years now. Since this year, I've been a PhD student under Professor Borges, focusing specifically on the legal aspects of deepfakes. After a brief introduction, I would like to go into more detail about the regulation of deepfakes under the AI Act. Finally, I would like to raise the question of certification. So, what are deepfakes? To begin with, let's approach the topic of deepfakes from a less legal perspective, looking deepfakes as they actually appearing on the internet. Some deepfakes are just quite harmless, simply funny images, like the first two images, for example. However, deepfakes are also created and shared for harmful purposes, as in the other two images, for example. From a legal perspective, several relevant actors may be involved when it comes to deepfakes. I would like to illustrate this with the following scenario. Each of these actors performs a different action that must be classified legally. The regulation on deepfake can address these various actions across different areas of law. In the following, however, I would like to examine the regulation under the AI Act in more detail. First, Article 3, number 60 takes a definition. This definition is very broad and vague, which can lead to the question whether every AI-generated or manipulated medium constitutes a deepfake. For example, I used ChatGPT to create an image of an apple that looks very realistic. According to the definition, this is already a deepfake, since it includes even objects and not just people. Furthermore, the question arises as to from which perspective the media must appear authentic or truthful. Is this sufficient in any person in the world perspective, the media as authentic or truthful, or must the group of people be limited? If a deepfake is involved, especially transparency obligations under Article 50 apply. Paragraph 4 specifically refers to deepfakes and mandates a mandatory labeling requirement for them. This obligation applies to the deployer of a deepfake AI system. However, the technical implementation of such labeling also falls under the provider's responsibility, who is therefore also obligated to label deepfakes under paragraph 2. In addition to the transparency obligation, a new prohibition of sexual deepfakes in Article 5 of the AI Act is now also being discussed as a part of the legislative process
process for the change to the AI Act through the Omnibus on AI. Last year's Commission proposal did not yet include further regulation of deepfakes. Last month, however, the Council included such a prohibition in its proposal. This prohibition addressed provider, deployers, and users as actors. Finally, I would like to address the issue of certification for deepfake AI systems. As just outlined, deepfakes are regulated only by transparency obligations and in the future by a prohibition according to the proposal of the Council and Parliament. A classification as a high-risk system was not adopted, although it was discussed during the legislative process for the AI Act. Therefore, there is no mandatory certification for deepfake AI systems. However, voluntary certification under Article 95 may be considered with regarding to transparency obligations and prohibitions. Many unresolved questions remain regarding the voluntary certification of these requirements, which we would like to examine in more detail. Who can be certified? Who can certification obtained? What are the benefits of such certification? A possible starting point for voluntary certification could arise from the supplementary definition regarding the planned prohibition of sexual deepfakes. This definition focuses on the foreseeability of the AI systems used for the prohibited purpose as well as on the technical countermeasurements taken. Further potential starting points could arise from other laws, such as in Germany from the duty of care under press law as set forth in Section 19 of the State Media Treaty. We already gained experience with this obligation last year during our legal internet project, in which we created and published AI-generated blog posts. So there are still many open questions regarding voluntary certification, which we like to examine more closely using the example of deepfakes. So I finished very fast.
Thank you very much. Well, we are really short of time, so I would like to invite the DHL team, and yeah, please, thank you all. And then Holger and Carlos Portugal Gouveia would also join this last section. We would, and then the idea is to hear this testimony by the DHL team about the challenges they have met within the effort of compliance with responsible AI. And then we will open to comments by Carlos Portugal and Holger. If you would like to join the table.
Can I start here?
Thank you.
Okay. First of all, thank you the opportunity. My name is Abner. I'm legal counsel in DHL Express here in Brazil. This is Sofia Cassaro. She is our legal manager here in DHL. For us in the private sector, it's quite brings some concerns about this subject because the advance of the technology probably we can't follow so quickly. So to manage a training or to understand this subject for us require a lot of time. I would say this day was great for us for sure. Was a great opportunity to understand how the German team and the Brazilian team is working in here with the Act and also in the Senate here in Brazil. We still have some concerns as well about the certification because in a local level would be hard to apply this in DHL or even in I think in the private sector. We still need to understand how to train or bring this inside the company to can achieve a level to be certificated in this kind of subject. Other point that we are talking about is the possibility of maybe a level of corruption inside this subject. We don't know how the background will be sustained. We don't know how they will work, and this problem can be a problem to JHL, also to the private sector. these points bring for sure a lot of concern, but I hope the government here in Brazil achieve a high level when this law will be applied. Do you have something to say, Sophia?
Yes, thank you. I would say I would summarize this in one word. It's all about trust. I think for the company, it's the most important thing.
Yeah.
We need to get trust. I think it's very clear that AI come to stay and make our work more efficient.
Yeah, for sure.
We have seen a lot of things been getting better with AI. Some positions being replaced by AI and people doing the more strategic work than
Administrative work.
administrative and the regular stuff. So, but I think we need to make sure and take care about the trust. And I think the regulation is very important. But I have the same concerns about the certification, the speed, the pace of this regulation and certification against the innovation. So I think this work, this joint efforts between Brazil and German, I think is a very good work, and congratulations, guys, for all you have done today.
Yeah, indeed.
Thank you.
Well, thank you very much, and thank you especially, Juliano, for inviting me also and for bringing this event to the University of São Paulo. Not exactly the University of São Paulo, but close enough. You've been, a force behind this effort for us to understand the relationship between artificial intelligence and the law in Brazil and in our university. And I'm especially grateful since you know that in the last few years I've been trying to understand the relationship between artificial intelligence and its regulation and the other kind of topics that I've been studying my whole life, which are mostly securities regulation and corporate governance. So I think the way that I can contribute to the debate here is talking a little bit about some of the topics that you discussed, but in my world, let's say, and most recently, the topic of certification has been a very substantial topic on securities regulation, especially with regards to ESG standards, so environmental, social, and governance standards. And I think there are like some similarities regarding the difficulties that we face and how hard it is to regulate both the attempts to implement ESG standards and also to create some governance of artificial intelligence, probably the two greatest challenges of our time. And I think one of probably a challenge that is in the background is our own conception of the legal system, because for a long time there has been misunderstanding about the legal system, as if the legal system could generate certainty, or what we call like legal certainty, or in Portuguese we say like the word is even worse, like segurança jurídica. And for a while, legal scholarship internationally has been questioning the actually capacity of us to both identify any kind of certainty on both the legislative process and also in the adjudication in general, both in administrative bodies and in the judiciary. So it's really hard when you look very closely to legal decisions to find any coherence on any of them. And so to a certain degree, we would think that, to a certain level, like this legal certainty is illusion. And the reality is that our societies have been built on top of, sometimes the uncertainty of adjudication. So the reality is the exact opposite of what we learn in law school. So This kind of like mismatch between what we think about the law and what the law actually is creates a lot of difficulties when we discuss topics such as AI governance or policies related to fighting climate change, because in those areas, the scientific background is really way more important than any legal framework. And that's also like very substantially true with regards to sustainability issues in general, because the standards, they're not only being crushed by the elephants, as Holger very interestingly pointed out, but they are also changing very fast. So, for example, when I teach classes on ESG, for example, the students you really have difficulty understanding like one basic concept, that is the concept that the standards or the criteria of materiality to apply these standards, they're dynamic, they change all the time. And for law students to deal with like something that is like a moving target, it's really hard, because for a long time we've been taught in certain areas of law, such as criminal law, that legal standards should be very fixed. It's a violation of fundamental rights if those standards are not very well clearly described in the law. And when we move towards both regulation of like securities in general and banking law, at least since the 1930s, when we started to figure out like modern regulation, that idea that this regulation is based on certainty has changed, because we know that the regulators are actually chasing like a moving target. So the levels of fraud in capital markets, they changed very quickly and they keep on changing. Like in Brazil, we have been witnessing like very creative forms of fraud, both in capital markets and in banking law. So most recently, our two main fraudulent schemes, like the one in Americanas that affected capital markets, was totally new, like completely new. It's a new kind of fraud. No any compliance system could catch it. And with regards to Banco Master as well, like it was a new kind of like banking fraud. Like you could say that the financial regulators, like the central bank, was low, but you can also figure out that they were facing something completely new, and they were not the only ones to fail. You had like several regulators, self-regulators, that failed as well, because there was something new being created. And of course, when we move that to computer science, that's something that computer science has been dealing with for a long time, since the times in which the first postulates were proposed that no computer science system is perfect. Every single system is supposed to be hacked at some point. And that's something that we, like the lawyers, we have a lot of difficulty dealing with that, like the moving targets and things like that. And for me, the only solution for that is to really understand that the producers of the standards, that usually would be, let's say, the government and regulators, they need to be strengthened. The only way for us, for them not to be crushed, would be for us to have very robust regulators. And if you look at the past, when we had to face in our society very challenging moments, that's what we did. So how did we came back from like the Great Depression? By creating very strong regulators. In my area in particular, we created like the most well-known like regulatory agency in the world, like the Securities and Exchange Commission, that was very important in basically guaranteeing that another economic crisis like the Great Depression didn't happen. And the thing is, and my question to you would be, can we actually create a regulator that would actually have the power to set those standards and oversee what's going on with artificial intelligence in the world right now? Because like one thing is to regulate, like it was a huge challenge for like actually humanity to regulate the capital markets after the Great Depression. Some people forget, but like the economy of the U.S. Lost about 70% of its GDP between 1929 and 1932. So it was like almost the end of the world, and we came back from it, but by mostly regulating the financial markets. But the financial markets are like a very limited set of like things that happen in society with a very limited number of people operating in this market. When we think about artificial intelligence, it's actually everywhere, as some of you already discussed. So my question to Holger probably would be, what would you envision as this regulator actually capable of creating standards that would actually not be crushed?
I think this is a very, very interesting and very challenging question. I want to broaden the perspective a bit. You discussed these kind of fraudulent cases where some new attacks were formed and so forth. But I think what we are basically seeing is, I mean, on the much larger scale, we are seeing what is, I mean, very typical, has happened a couple of times, that there is the ambition to create a new market, be the first on the market, and then to monopolize the market and be early enough so that regulators actually need some years, right? And in that time, basically milk the society, right? I mean, we have seen this with electricity and so forth a couple of times, and now we are seeing this basically in AI, right? I mean, we see different AIs with different strengths for different purposes, and essentially this is about, I mean, indeed, I mean, satisfying demand, obviously, but at the same time trying to monopolize and then to make money, and the investments are so high that basically, I think this is fair to say, research on AI no longer happens in research. It happens in the big companies. They are the big tech companies are the ones who have the hardware, they have the brains, and so forth, right? And so essentially, I mean, this is unprecedented, I think, and it makes it very, very difficult to catch up with this. But I don't know. I mean, I'm not afraid of this super intelligence and all this bullshit, right? So I'm not saying we need a kind of memorandum or something like that would say, let's stop with this and so forth, right? But I think we should understand that this is essentially driven by these enormous market forces, and that this is by itself something that cries for regulation, basically. That's all I can say. I cannot say how to, but I think we should be super careful. And I think what you are saying here, I think was extremely good. This is all about trust, right? I mean, when we were saying autonomous systems, we kind of like this. Autonomous cars, how great, we don't have to drive anymore. But if you have an autonomous system in your company that does certain things that you don't know what is happening, right? I mean, I'm sorry, this is probably not the autonomy that you want, right?
Yeah.
So,
Yeah, exactly.
yeah.
I have a reaction to Carlos. I think that we have to be careful with having too much expectations in an external regulation by the state, not only regulation but also enforcement by the state on about responsible AI. So I believe that the AI will be so ubiquitous that it will be really impossible for regulations, external regulation or centralized or even decentralized regulations, as in the Brazilian proposal, to enforce and to control the compliance with all these systems. That's why one alternative is to bring the private sector, not only to bring codes of conduct, but also certification schemes to help with the enormous burden for this fiscalization and this enforcement. But also, we should come to the point that AI systems should be able to enforce responsible AI and enforce the law themselves. So what I mean, AI agents must become intelligent legal agents also. We humans are intelligent legal agents. We have our notion, we may cheat sometimes.
We can
Okay,
fail.
to avoid what we disagree, but of course we are intelligent in the sense that we can process and understand what is right, what is wrong regarding the law, regarding morality. We may not act according to what is right or what is wrong, but we can reason about and make conclusions and choose actions also considering legal consequence or moral outcomes. So AI systems must gain this capacity so that many of the decisions will be self-enforced, also considering law. So that's my reaction to it. I think that we should take care not putting too much burden and expectations on an external authority. I have now a provocation for both of you. So imagine the seller of certification entity, a certification company, comes to the DHL, knock on your door and wants to sell a certification program to you. You told about trust. So what would you want to hear or expect, or what would bring you trust and so that you would buy and join the certification program? So what would trigger this trust in the narrative of the certification?
I did this same provocation today. I told him, who is going to certificate the certification company? How can I be sure that this company is in fact able to do that?
So that would be the state, if the state would validate?
Yes, but if it is an international one, probably we are gonna make like the ISOs, this kind of company that will bring us the information on how they will work on this.
A guideline, for sure.
Sure,
Probably in a global level, I think we would receive a guideline to understand, and maybe in a global level, trying to replicate something similar in a local level. So if a Brazilian company try to certificate DHL here in Brazil, for sure we will trigger this in a global level to understand if it's possible, the first step, and if it's not possible, maybe in a global level they will send some certification, an international certification to reply here.
And we have other certification for security, for example, because
Yeah.
we are inside of the airport, so we should have this international certification for security. So probably it's,
but this is mandatory.
Yeah.
Yeah.
Some voluntary certification program. Okay, good.
I mean, that's an interesting point that you're making here, but it's probably good to know that under the AI Act, for instance, there is a notifying bodies which do the certification have to be notified by the authority, and that is the general principle of certification. Really, is that there is one supervisory body that accredits or not certifies the certification bodies according to certain standards that have to be met. And I think this is a general principle of reliable certification, that there is a full chain of trust, and that in the end there is the root of this chain of trust must be the one who is giving legal effect to the certification. So whenever Brazil would make a law on legal effects on voluntary certification, which is the obvious demand that should be done, then it is important that there is an authority granting the legal effect to the certification that makes the supervision on the notifying or certification bodies according to well-established standards. That was not well understood in the past. So we have a zoo of very uncontrolled certification schemes, but that's obvious what has to be in place, and we can see in international comparison that there is a develop of a general theory of general standards of reliable certification.
Yeah.
Yeah, I think in terms of cybersecurity in DHL, at least, we are going to follow the guidelines, and I'm almost sure that we would rather to work with certificated companies than others. We saw this with data protection, the governance with data protection, and all these systems. When 3 years ago, when we started this boom with AI, generation AI, the first thing that DHL did was block the ChatGPT and create their own. But they understood that we are not fast enough with this, because we are not a technology company, we are a logistic. So now we are hiring a vendor. Now we contracted a vendor for AI. And of course, we do have other agents to make our operation more efficient. But following the past, I understand that we would rather to work with trust companies than hiring all kinds of vendors.
Okay, so thank you very much. We unfortunately will have to come to an end to our extensive day of debates and very interesting interventions. This last point that you made is very important. For instance, in the data protection regulation in Brazil, we had a strong movement of regulation, and companies were compelled to commit themselves with the compliance with these rules. But in the end, the data protection authority proved to be very weak because of budget, and there were in 8 years just a few fines and interventions by the authority, and I believe that this will have an effect also regarding the Brazilian AI bill, if it's approved. That is, because of course it's not only publishing a beautiful regulation, it must be followed by enforcement. And I have my doubts if we again will be able to structure an authority strong enough and with resources for that. And this is another reason why we are investing in this question about certification and developing this project with this wonderful German team. And I'm very grateful that you have visited and enlightened us with these contributions. I hope that we had also brought some insights that we now can work on for the next years. Okay, so thank you all, and so keep updated in our websites at Logarithm for the developments of this project and the events that are going to be developed within this project. Thank you very much to all.
Thank you.